Good morning, everybody. Welcome to the Courtroom Files Live. It's a Monday. This is the 3rd of November, believe it or not. Michael Groff filling in for Dan Soul once again, all week long, stuck like Chuck with me. Thank you so much for joining me. We've got lots of stuff lined up for today. Should be a fun day. We'll try to turn a Monday into another day other than a Monday. And to do that, we'll start with Judge Shackelford.
All right, good morning. This is 252010 the People versus Brendan and Gibson.
For the narrative, we on behalf of the Gibson, they signed a date set for sentencing. We had an opportunity to review the pre-sentence report, saying that there's the actually accurate. Some things I'd like to address on the recommendation.
Okay. Go ahead.
Okay. I didn't know if you wanted to hear from
Ms. Havner first or
anyone.
I know let's do this. I have Miss Bunch here, the mother of the victim in this case. Miss Bunch, it's a time and date set for sentencing. You have a right under the Michigan court rules or Michigan Constitution to make a statement on this case. If there's anything you want the court to be aware of prior to sentencing. Ms. Bunch?
I did write out a victim impact statement as I was asked. Would you like me to start that?
Yes, please.
Okay. Brendan, you've changed our daughter's entire life in a matter of minutes. You've put horrible effects on our daughter's brain. It's scientifically proven that a child who falls victim to physical abuse, that their threatened stress response becomes overactive, leading to a hypervigilance, which our child is now experiencing, as well as you've altered her reward and motivation system in her brain. She now has a hard time having motivation to do nearly anything, even super fun activities. You've caused molecular damage to our daughter, which all spouted from the beating she received from you. She has social anxiety. She is scared of doctors. She is scared of police officers. She is scared of humans. She's scared of you. Our daughter is scared in a way she never was prior to July 2025. Brendan, you were supposed to be her protector, her savior, and someone she can lean on through anything, no matter what. And you ripped that away from her. You became someone she needed protecting, saving, and healing from. You promised many people you'd never stoop this low. This girl was your absolute best friend, and you were hers. How do I explain any of this to my child? How do I fix what I didn't do? How do I help her be okay? Because you've put it all on me, and it's getting pretty hard watching my child be so sad and so confused. All I can do and actively do day and night is pray, and I will continue.
Ms. Bunch, thank you so much for sharing that. Mr. Fanto, anything?
Your Honor, just a couple things before the primary comments. And I spoke with Ms. Havner. He is required to do a parenting class through circuit court. He's had an intake, does not have a class scheduled yet, but it did an intake for that. And we just ask if he provides proof that has been completed according to the circuit court / CPS requirements, that be allowed to count for the parenting class that's being recommended, obviously providing appropriate proof. The other thing is in terms of the GED, I would ask that be a deep secondary goal. I would not want that to be anything that he has to address until he gets all his other classes out of the way. That's a lot he has to do, and he recognizes that and understands the responsibility that he needs to do that. I would ask that the court, number one, change the language to work towards, and number two, not make it an issue until such time he successfully completes the other classes that are being required.
All right, Ms. Havner, is there anything else that needs to be added? I mean, I reviewed the report.
Yes, Judge. No, I'm fine with working towards the GED. I know that he has gainful employment, but I do think that having a GED or a high school diploma equivalent is important, but I'm fine with it being worked towards.
All right, thank you.
I just
I'm sorry, go ahead.
addressing the main issue, or the overall issue. The report leans towards a feeling that Mr. Gibson does not take accountability for this. I've had the opportunity to speak with Brendan on multiple occasions and from the get-go, if I recall. And he's always expressed regret to me. And he doesn't speak for a living. I don't think anybody knows how to speak anymore, quite frankly, because they're too busy texting and don't understand context and how to talk to somebody. And he doesn't do that well. But he's complied with the circuit court and CPS. He sees his daughter every Friday for 2 hours, reports those visits.
Supervised,
Pardon me?
supervised,
For now, yes, they're talking about.
as it should be, right?
And that's, that needs to be worked back through, and that they're supervising all of that, Judge, and that's appropriate. And he reports that those have gone well. He's
I have the
had,
actual reports. They did not go well.
All right, Ms. Bunch, it's not, thank you for sharing that, but let Mr. Fanto finish, okay? And if you have any closing remarks, I'll ask you at that time, okay?
Yes, ma'am.
All right, thank you.
So I think it's important the court understands that he understands this was not appropriate behavior at the very least, and that he does regret it. He does understand that he did not act accordingly in terms of the proper disciplining of a child, and he gets that. The other thing I would like to address is the 10 days forthwith. Mr. Gibson's been employed by Target Steel for 2 years. He makes a good living, has his own house. I would request that if the court's inclined to give him any jail time up front, that he be allowed to report Friday at 4. He works a 1 to midnight schedule, and then he has his parenting time or visitation with his child 1 to 3 on Fridays.
It is at 11 to
11 to 1, I'm sorry, 11 to 1. And we'd like to be able to do that this week, and that would eliminate really missing 2 weeks of that time. And could we approach it?
Yeah.
And while they approach, welcome everybody. Good morning again. It's the Courtroom Files Live. It's Monday. We're hanging out in Michigan with Judge Shackelford to start the day. We've got a lot of other courts going on, so there are plenty of places that we can go, but we don't often go to Judge Shackelford. But since I've been in the chair here, we've been able to do that a couple of times. It's been kind of nice to go to a few different places. We've got a lot of the usual suspects up this morning, so we'll check in over there and see what's going on. Now, we are a little bit in the Wayback Machine here, so I think we could try to nudge this forward just a little bit and see if we can get this back on track. But I don't know if that's going to happen. There we go. We are back with Judge Shackelford. Again, good morning, everybody.
May I ask what's happening? I've seen that.
Or maybe not.
May I ask what is happening? I've seen that everybody left the courtroom and I got muted.
Judge and the attorney and the probation officer went into our chambers to have a conference, so they should be out in just a moment.
Okay, thank you so much.
Yep.
kind of weird to see that happen, you know, in the midst of sentencing, in the midst of victim impact and all that. Just everybody gets up and sort of bails out. That's something you don't often see every day. So that's why we do this live, right? This is the very point of TCF Live is to experience this sort of thing. All right, we are back with Judge Shackelford.
Ms. Bunch, well, let me ask this first. Mr. Phantom, is there anything else you or your client want to say?
Only just as to one sentence in the thing, he indicated that it was worse of the fact, just handprint marks or finger marks. He meant that in the context that while inappropriate, clearly with the results, that he didn't use any other, a paddle, didn't use, any other item to do. That's what, when you read that sentence, it certainly doesn't come out well.
He was saying I didn't use a weapon.
Yes.
Okay. All right. And Ms. Bunch, anything else you want to say to the court?
Yes, men are automatically born with extra muscles than women. I'm sure that we've all received a spanking in our adult life and our children's lives. As adults now, we can recollect that spanking was red and went away. My daughter was black, blue, and had blood blisters on both butt cheeks for days. She may have not been hit with a weapon, but angry enough, his hands are weapons.
Yeah. Well, Ms. Bunch, I'll tell you, that's not a very convincing argument for me from defense anyway. I can't imagine
I'm not here to
using
convince
my
you of anything.
hand. I mean, I'm with you on it though. Like, to me, using my hand and striking.
How hard did he hit her?
4-year-old over.
She was 3 years old at the time.
Even worse. I mean, this is still like a baby.
Because I've been hit by him and it didn't come out that bad. How hard did he hit her?
All right, let me impose sentencing here, but I don't disagree with you. I cannot imagine using my hand over and over on a 3-year-old kid. I can't imagine using my hands on anyone.
Screaming.
Yep, Ms. Bunch, you gotta let me talk because my court recorder can't take us both down. But I'm in agreement with you. This is egregious. I saw the image. I saw the marks that were left on a 3-year-old. I just can't even imagine what you would think as a parent. Like, there are 2 people in the world that are supposed to protect this 3-year-old from harm, whether it's sexual abuse, physical abuse. Miss Bunch, you gotta let me talk or I gotta mute you. Okay. Please, I'm with you, but let me do it. Whether it's physical harm, sexual harm, verbal harm, neglect. There are 2 people in the world that hold that child's completely dependent on you. This is a baby, basically, a toddler. And that anybody, when I look at the picture, I just remember and I miss these days, and most parents of older kids will, when like kids have those like little chunky, cute baby bodies, right? And to think of striking a baby over and over and over, it's repugnant. It's beyond bad. It's bad. Like, I don't understand what you could have been thinking. And when I look at and I understand some people aren't the most articulate, even taking that into account, sir, like, I get it. I talk for a living, right? You don't. I get that. But that you said, well, that your ex is always trying to get you in trouble. I'd be trying to get you in trouble if I was your ex too, if you were beating our child in common. So, like, your lack of accountability or self-awareness that your behavior was so beyond what is appropriate for discipline, especially for a toddler. I just don't understand what could have possibly been going through your mind while you were, and this is the thing about, if you're going to use physical punishment against your kid, you're the grown-up. And when you do it, you're not supposed to do it out of anger. And I'm not saying you should do it at all, but it's supposed to be something that you do deliberately to send this message, but you never hit a kid out of anger. And when I look at what you did to her, That is clearly, you had no self-control. When you did that, to hit a kid like that, you had to hit her over and over and over. And you have no self-control. And then I look at your record and look, there's a plea agreement on this case. And there was a sentencing agreement, but I look at your record and like you've had 2 assaultive cases since 2020. So this is your 3rd. You had something in 2020, something in 23, and then now we're in this case. So in that short period of time, you've had 3 assaultive criminal convictions. You should be ashamed of yourself. You really should. And the damage to your relationship with your daughter, how's she supposed to trust you? Like one of the 2 people in the world. And you know, kids as they grow up, they're less and less reliant on their parents. But a 3-year-old, she needs you for everything. She can't feed herself. She can't go to the bathroom without assistance. She needs help taking baths. Like this kid needs you for everything. And I would be very concerned if I was Miss Bunch with you having any unsupervised time with this kid, because it's clear to me from this incident that you lack self-control, and hopefully your parenting classes will help you and your anger management and all of this. But like, this is a serious problem. You cannot treat children like this. They remember stuff. And you know, if you want your kids to talk to you when they grow up, this is not how you raise them. This is, you are setting yourself up to be the kind of person who doesn't go to your daughter's wedding, who doesn't go take pictures of your daughter at homecoming, who doesn't have a relationship with her when you're old, who doesn't see their grandkids. This is the start of that. That's how you get there, because she'll remember. And she'll be old enough someday to make her own decisions, and she won't have to see you if she doesn't want to. You have a fine of $50, court costs of $50, state costs of $50, plus a crime victim's rights fee of $75. You have probation oversight fees of $600 and a community service fee of $100 per day for a total of $50. That brings your total to $875 to be paid. You can have a payment plan over the course of your probation. If necessary, you will do 18 months of probation with no early release, and you'll report as directed. You'll do 10 days jail. I will allow you to turn in on Friday. You can work out the details of that with Ms. Hafner. You'll do 5 days or 40 hours of community service in the city of Taylor as directed by probation and provide proof. You'll abstain from the use or possession of alcohol or controlled substances unless they're prescribed by a physician. Documentation will be required. And that's for the term of your probation to be subject to random drug and alcohol testing as deemed necessary at your expense. You'll complete a 26-week batterer intervention program in person or as directed by probation through Pam's Place. You'll provide proof and follow all therapeutic recommendations. You'll do a 6-week anger management program in person or as directed by probation through Pam's Place. You'll provide proof and follow all therapeutic recommendations. And I'm gonna just make a note on this comprehensive parenting program in person as directed by probation at Pam's Place. Ms. Havner, I don't know what they have him doing through CPS and if it's comparable to this program that you've recommended. So if you can look into that, and if they're both the same length or duration or cover the same material, I'm okay with that. But he'll have to provide some, you're just gonna have to do a little looking, I guess, and see if.
The one at Pam's Place is 14 weeks.
Okay.
So I will get with CPS and see
what theirs is and what it entails. Because if he went to a 2-hour class and had to, do something online, then no, he can do this too.
Right.
But if it's comparable, I don't see the point in duplicating that, except for maybe after 2 times it'll get through his head. You'll have time to complete any other ancillary services deemed warranted. You're to have no contact with Melissa Bunch or Everly Gibson unless in accordance with family court and CPS. You maintain employment and provide proof. You cannot have any weapons or ammunition. You will work toward boards. So the GED, I think it's good for you. I think you should try and obtain it. But given the nature of this case, I'd much rather you work on how to control yourself, No operating without a license. And if you haven't been fingerprinted, you're to be fingerprinted. Anything else?
Something from there, I think.
All right, we're all set.
All right, pretty hard-hitting case to start the day for a Monday. Nothing like a little child abuse to get the day going. It's TCF Live. It is Monday, and that's Judge Shackelford, and we'll check in with her throughout the day, see what's going on, provided that she continues with the docket up there. I suppose we'll stay in Michigan. Oh, by the way, thank you, Grandma TCF, Mama Joan, for the $10 super chat. Really do appreciate that once again. Mama Joan, that's Dan's mom, supporting us, and we really do appreciate all that she does to help out here as well in Dan's absence. It takes a village to run TCF Live, that's for sure. Let's stay in Michigan, not far from Judge Shackelford, and we'll check in on Judge Dad, see what he's got going on over there this morning.
Okay, good enough. All right. Do I have Little Owl Treehouse versus Perivia Jackson?
Judge, they're coming out of the breakout room right now. I had placed them in to speak. They're on Zoom.
250444. Ms. Jackson, good morning. Your name?
Good morning. Perithia Jackson.
And Little Owl, who do I have for you guys?
Hi, I'm
Okay.
Rose.
Wait a minute, somebody needs to start the video for Little Owl Treehouse.
Okay. Did it start?
Yeah, you're in the courthouse, huh?
Yes.
All right, what is your name, ma'am?
My name is Rose Milano.
Can you spell it?
Milano.
Oh, and first name is Rose?
Rose.
Wait a minute, say that again.
Rose.
And then Milano, Milano?
Yes, sir.
What is your position with Little Treehouse?
Office manager.
And you have knowledge of the facts and circumstances of this case?
Yes.
Ms. Jackson, do you owe this money?
No, I don't owe 600. I do owe 200.
Are
They're
you in the
claiming
courthouse right now, ma'am?
I am not.
I'm sorry.
I'm at a doctor's appointment with my son. I'm at an ABA appointment with my son. I could not cancel today.
Did we tell them that they had to be here in person, Jen, or not?
Judge scheduled in person. I saw Little Owl was on Zoom. I did not realize she was in the building. So when Miss Jackson called, we told her she could Zoom in because Little Owl was on Zoom. I did not know she was in the building.
You got to show up in person. We didn't tell you didn't have to show up in person on this, did we? It's a small
No, I
claims
didn't.
action.
I didn't realize that. I've been in court all year and I've been doing it all by Zoom. So I did not realize that this wasn't a Zoom appointment, and I will admit that.
Everybody else feel that. Jen, you good?
Ms. Milano,
Yes.
before we go on, do you want to tell me, because I might adjourn this.
If Barry had anything of a-
I'm sorry, I didn't hear the question.
One yet, all right, by giving up certain rights. You're giving up the right to appeal my decision. You're giving up the right to hire a lawyer. You're giving up the right to demand a jury trial. And to the extent that you may be entitled to it, plaintiff, you're giving up the right to seek in excess of $7,000. Now, you don't have to give up those rights. If you want to preserve any one or more of those rights, though, just tell me. Remove the case to the General Civil Division. I will still be the presiding judge. I will be the one who make the decision, but it will become much more formal. However, You could hire a lawyer, you could demand a trial by jury, and if you don't like my decision, you can appeal. Do you understand that, Ms. Milano?
Yes, I do, sir.
Do you understand that, Ms. Jackson? Ms. Jackson? Who are
Yes,
you
yes, I
talking-
do.
Who are you talking to?
Like I said, I'm at an appointment with my
Who are
son.
you talking to? Who are you
I'm
talking?
I'm talking to you right now.
When you look to your right, who were you talking to?
I'm at an appointment with my son at an ABA center. I'm still having childcare issues at this time.
Who were you talking to?
I'm telling you, the person that is with my son at the ABA center, at the autism center, he's at an appointment. They brought him out for a minute to me because I guess he was crying, and they're going back in now.
You wish to give up those rights and proceed here, or do you
Yes.
wish to? Do you wish to give up those rights and proceed here, Ms. Milano?
Yes, sir.
I still might adjourn this, but I'm going to try right now. I'm going to ask you both to raise your right hands. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth self you got. Ms. Milano?
I do.
Ms.
I do.
Jackson? Okay.
Yes.
All right. Why don't you tell me how you come out to 600?
I have an invoice too, and actually, the boss, the owner of the thing had agreed to $430, and we had given her several chances to come in and pay that. And each time she was supposed to come in, she never showed to pay any of it. So now it's $430, which includes late fees, and it's also going to incur costs.
Okay, let's talk about how much she had in shelter expense there without late fees.
She was, let's see. It looks like she was $100 a week for her child because he did not attend full
How much
time.
was the balance when how much is the balance excluding costs or late fees?
430 plus course costs.
But what about the late fees? I want you to exclude the late
That's
fees.
included in there. It was 230, and then he included the late fees and brought it up to 430. And then add
Slow
court
down.
costs.
Slow down. I want you to just answer my question. Forget the late fees for a second. Was the badge $30?
Yeah,
I'll include for late fees.
he included $10.
$10, how often?
He just added $10. That was it. So it brought it up to 430.
Wait a minute, come on now.
Oh,
You
I'm
gotta
sorry.
you
I'm
gotta
so
listen to my
confused right now.
question. Wait a minute. You gotta listen to my question. You gotta be more specific. If she only owed $230 in childcare expense, he charged more than $10 in order for you to get to $430, right?
My original thing was that she owed $600. She never
Oh.
paid anything on that.
Ma'am,
I did.
Okay.
you guys, listen to me very carefully. I want you to listen to me, please, Ms.
Yes, sir.
Milano. I just want to know what she owed for childcare, not filing fees, not service fees, not late fees, just for childcare. What was her
She
balance?
She owes $400.
No.
Ms. Milano, wait a minute. You got to listen to me, man. You bounced all over.
I'm so sorry.
You said it was
Okay, my paper-
$430. And then you told me,
My
it was
paper
$230
says
and there were
$230.
$10 in late fees. $230 and 10 is $240.
You want her to come in?
Yeah, why don't you come in here?
Okay. Pardon?
Where's the tablet?
Oh,
Give me the tablet.
underneath. There you go. Thank you.
Hang on.
Okay.
Who's that good looking guy walking down the hallway?
My Jesus.
They'll be here in a second. We'll resolve this, Ms. Jackson, okay? Just bear with me.
Well, thanks for bearing with me. My son is like having a fit.
I'm sorry. I really am. Come on up here, Ms. Milano. Now, I want you to listen to my question. First, you said 4:30. Forget about what you said.
Okay.
I want to know if you just include the child care balance. Forget the late fees, forget the costs, forget the filing fees. How much would she owe you if there was no interest, no late fees?
$200,
You said 230 to me 10 minutes ago, 5 minutes.
100, and then he had a court cost or late fees, which made 430.
How much are the late fees that you charge?
They must have been $10 per week, sir.
Well, they're not gonna pay. How much did she pay? $100 a week for a child? Yes?
No.
Is that true or false, Ms. Jackson?
The original balance, so at this time, my son was no longer attending the center. I took him out because I couldn't afford to pay anymore. The balance was 600. I made a payment plan with him to pay $100 weekly. I paid up 400 of it, and then the last 2 weeks I did not pay. I'm going. I could barely pay my mortgage, so I did not make those last 2 payments. However, I never ran from the payments. I responded to every email. I
They
always kept in
can't
contact.
charge, yeah, they can't charge. Do you realize how obscene that is to charge $10 on a $100 bill every week? I mean, I want to go into that business. I mean, I feel badly for people or companies like this that are not paid. Okay? But you can't do that. How much was the filing fee? Jennifer, I want you just to double check this for me. The filing fee was 48. Did you have any service fee, ma'am? No, she signed for it, didn't you?
Yes, I did.
All right. Well, I'm gonna give them a little bit of late fees, but it's not gonna be anywhere near. Is there anything else you want to say, Ms. Jackson?
No, I never. They know I've been in communication with them the entire time, and I've never tried to not make the payment. It was just my
I
financial issues.
understand. I understand.
I understand that, Your Honor, she did say I just don't have it, and I did give her a couple of times to, she agreed to bring in $200 on August 1st, and she did not at that time.
Let me ask you a question.
Yes,
How long was the bill outstanding for $200
the bill that I have in front of me was actually from November.
of last year?
Yes, sir.
All right, here's what I'm doing. Have I let everybody finish, or does anybody want to say anything to me here?
No, I meant to owe in a debt.
I'm sorry, I didn't hear you, ma'am.
I said, no, I don't have to say, I don't need to say anything else. I do admit to owing the $200, but not the 600. That was my only issue on the paper.
All right, I'm gonna go, is there anything else you wanted to say? Anything else?
No, sir.
Here's what I'm doing. I'm giving you the 200. I'll give you 50 more in late fees, but you can't charge $10 a week. $48 in filing fees. The total's $298. Now, Ms. Jackson, you said you're going through divorce. I get it. I can set up a payment plan for you. Can you pay $50 a week?
Yes.
Starting when?
Can I start next week, not this week?
Yeah, what day?
I have to look at the calendar. I don't
Just
know
tell
what
me the
this
day of
Friday
the
is.
week. What day do you get paid next week? You
Friday.
get paid on Fridays?
Yes, I get paid on Fridays.
Then let's start it on the 17th. You pay $50 bi-weekly, okay? I mean weekly. $50 weekly starting the 17th. You have to pay it direct to them.
Okay, I can do that.
Okay? I wish you well. We're going to send you a copy of the judgment, Ms. Jackson. We're going to give you a copy of the judgment, Ms. Milano.
Okay.
Wish you both well. Thank you very much.
Thank you. You too.
That sounds like the plaintiff there was engaging in a little bit of fast talk in there, a little slick Rick action with the changing of the amounts. Good morning. It is the Courtroom Files Live on a Monday. And I'm just having my coffee here. We're hanging out, just watching some court, doing what we always do here, and getting through a Monday to the best of our ability. Well, all of that having been said, I suppose we could take this action down toward Texas. Check in with Judge Stevens. Looks like he has a contestant coming down that's up for on a first-degree felony, engaging in organized crime or something like that. So let's see what is happening over here. Oh. So I just realized that we're having some audio issue here. Looks like. Luckily, well, I forgot to turn up the monitor in here. All right. Well, it's a Monday. My goodness gracious. Okay. Well, let's handle that to the best of our ability here. We're going to go ahead and let me take care of this real quick. Oh my goodness gracious. It's a Monday, everybody. Very professional operation that we run here sometimes, I know. Let's see. All right, I gotta fix that. Now I've got my monitor going, so there we are. Michael Groff filling in for Dan Soul. It's obvious. Yes, I know. It's, again, highly professional, highly organized broadcast that we run here. And we will get you back to Judge Stevens. And, I could have actually probably just maybe done impressions of the audio. Maybe that would have worked out better, but whatever the case. All right, let's try this again.
9A. You were charged with first-degree felony engagement in organized criminal activity. And Mr. is your attorney. What are we going to do on this? Where are we headed? Is this going to be disposed of, or are you going to try?
I don't know what to do, honestly. I haven't been well counseled by Mr. Duke.
How do you know that?
Because he doesn't want to do. He's not
counseling you.
He's not giving me nothing besides vague talk. It's nothing.
That's what lawyers try to do. That you have to make up your decisions. They give you what the options are, and what the strengths and weaknesses of the case seem to be after discovery.
I'm not getting any of that.
And you just interrupted me. I can understand why he's having a problem with you, maybe. That's kind of rude. Both of us can't speak at once. We learned that at first grade. All right.
He's rejecting the state's offer, asking to be set on trial like that. I've asked the court to.
You're not able to hire somebody, are you? You're an indigent, right?
Yes, sir.
Okay. Has he filled out the indigent thing? Do you remember filling out an indigent form showing what you're?
Yes, sir.
It's not in this file. Let me do. I don't have a file. You remember filling out something for him or with him?
I didn't too. I think it was done.
We got it. It has to.
I did it.
It didn't. A hard copy was not made. So much.
On Saturdays and Sundays, just behind.
Yes, sir. It's in our electronic law.
Let's see it.
Yeah. Yes, he says it. Yeah. You guys class earlier. It's a class.
Copy of that.
I didn't say.
Let's move with that.
How many times? Enjoy. Yeah. 1 year and then after probation probated. Years. Okay. We got a call back there. Did we get?
The last time you had an income was what? What was your income?
It just varies.
What do you do? What's your profession or your occupation?
Recording engineer.
Sir?
I work in a studio, a recording studio.
Recording studio. Are you good at it? Okay, it shows like, this states your take home pay was 2,000 a month back then. Right now you have no income, isn't that right?
I've been in jail.
When you're in jail, you. All right. Statuses and which still include indigent. And so an attorney will be appointed to represent you. And, your attorney here has been appointed, has been unable to, resolve it without a trial. We're going to just set it for a trial. And Mr. Dusler is a competent lawyer. He can certainly do a good job. Are you asking the court for me to relieve him and appoint somebody else to represent you at trial?
He doesn't want to work for me.
Is that yes?
I guess so.
Okay.
I'm not aware.
But I mean, how many times have y'all spoken to each other? And then,
We smoked maybe 3 times. He doesn't want to really communicate with me at all.
all right. Then I'm going to find good cause to release him. The next person on the trial docket will be appointed to represent you, set this for trial. And I'll see where that is. We'll try to get it as soon as possible. Okay. Anything else? That is all. Thank you.
I can ask a question, Joe? I can ask a question.
Go ahead.
So there's no way to get a bond reinstated or any of that?
Not while you keep testing positive for drugs.
Is there anywhere I can be drug tested?
Yeah. Well, we've been testing you regularly and you keep testing positive for THC, tetrahydrocannabinol. I don't know how that's happening in the jail.
No,
You're getting marijuana, but you're testing positive. But that's the problem because each of positive test is a crime. You're illegally possessing drugs. That weighs against you on getting a bond. If you keep yeah, when you want to stop interrupting me, we'll bring you back out and we can talk. But every time you interrupt, you ruin your communication with me, sir. All right, so Mr. Buren is set for trial. And Sam Hodges. I need Sam Hodges next. What are we gonna do on this one?
I think it's gonna go to trial. We're close to resolving it, but he just doesn't want to take the offer that's on the table on the state. I think it's pretty firm with their offer.
Sam Hodges, please. Thank you.
I don't know you did.
Something.
Don't give them wait for. You know, listen.
What happened? You're Sam Hodges? Correct?
Yes, sir.
You have 4 cases here. Engaging in organized criminal activity, a state jail felony with several prior convictions. I guess that is bumped. It looks like state jails. That bumps up to a 3rd-degree felony of punishment. And then robbery is a 2nd-degree felony with a 1 prior conviction in 2019 out of Harris County. So that gets bumped up to a 1st degree on that one. 25 CL 1022 was a burglary of a vehicle, state jail felony, and it has 1, 2 convictions. And it looks like that goes up to a state jail felony punished as a 3rd degree
Yes, sir.
Yeah.
On the way the two burglary of vehicles are indicted, they are enhanced to state jails from the original offense
Okay,
charge.
so it's a state jail felony on that.
Yes, sir.
Then finally, a burglary of a vehicle, 1023. It looks like it's the same type. It's a state jail felony, state jail felony. So two state jail felonies, a state jail felony in robbery, which is enhanced to a first degree felony, which I guess is the one we would try.
The robbery is the one I would try first.
And then engaging in organized criminal activity is the state jail felony. That
Yes,
looks
sir.
like it is enhanced to a third degree felony. Okay, we'll be busy. So what are we gonna do? What's the
Judge,
plan?
the state has offered him 8 years on the robbery. Dismissed state jail felonies, explained that to him and the consequences. And he still feels that's excessive and you don't like to take that. Is that all right?
This has previously been on the trial docket. If you would expedite it, I would love to try the robbery case.
Then that's what we'll do.
Okay.
It'll be said.
Do you want?
Get this, let's get
Me and get a different
in the
lawyer?
next few weeks, please.
He's asking, get a different lawyer. So.
Why do you want to get rid of him? He's a great trial lawyer. But what do you want?
You want to do it as soon as possible?
Is that, you have to speak out so she can hear you? Okay, you said yes. All right, it'd probably go to trial quicker if you agreed to release him, if that's what you want. To get this thing to trial quick. All right, then I find good cause to release Mr. Duva, next person on the trial docket. Will be appointed to represent the will try this case. Thomas Smith.
When you brought up, that is a plea.
Thomas Smith is next. Yes. And then while we're doing that,
While we wait for the next contestant to come on down, it's Judge Stevens we're hanging out with here in Texas. Michael Groff filling in for Dan Soul. It's a Monday, another week here filling in for Dan on the Courtroom Files Live. Thank you so much for joining us. Hang out in the chat with us. It's a great community. Consider joining us, becoming a channel member if you like. You get it's just $2.99 a month, and you get to join us for the pre-show and a whole bunch of other exciting benefits. And you're supporting the channel, so maybe think about doing that as well. All right, we are monitoring a bunch of other courtrooms as well. We'll go somewhere else in a little bit, but we're just hanging out with Judge Stevens for a bit and see what's going on. I've been wondering what's happening with Judge West. We haven't seen her in a while. We'll try to figure that out. Meanwhile, back to Judge.
Yeah, we're okay. He's on bond. Yeah.
Here, Ms. Finnegan.
She needs to.
Raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, self is God. Okay, pick up your right thumbprint. Place it flat right there. Don't let it. You get up one more time.
That'd be a pleasant change. Be a pleasant change.
Place it right here.
21-37777. Well, there's a lot of sevens in there. That's good luck. It's always been good luck for me. Is called the State of Texas versus Damian Naveau. You, Mr. Naveau, present with Mr. Comp, your attorney and the state's attorney. Does the defendant waive reading of this indictment? Can we proceed in summary?
He does.
All right. First of all, this alleges the third-degree felony of misapplication of trust funds. Apparently, a deal has been worked out where the defendant.
It's a lesser included, it's Class A.
How is it a lesser included? So we don't have.
Because you take the intent to defraud out, and it's a Class A misdemeanor.
Here's the penalties and the statute when we look at it. It's property code.
It was indicted out of section 162.031.
It's on the other side of the page. Yes, sir.
Oh,
It's got the statute and then it's a Class A misdemeanor except for if
which
it's
code is this?
property code.
The property code.
Yes, sir. That's why I printed off a copy for you because I know that I'm just keep my line out.
Start with D. And,
All right, we're proceeding, it looks like on, under this statute, which statutes outside the penal code are always seem to be worded a little more hard to understand, complex than what's in the penal code. But here, under section 162 of the Texas Property Code, there is a provision concerning punishment and illegality, criminal illegality for what is referred to as misapplication of trust funds. And a person who intentionally or knowingly or with intent to defraud somehow misapplies trust funds, then that can be an offense as high as a third-degree felony. The statute goes on to provide under section 162.032 under the penalty section of part B, a person who misapplies trust funds amounting, under part A of the penalties, a trustee who misapplies trust funds amounting to $500 or more in violation of this chapter commits a class A misdemeanor, which is, I think, the portion that the parties have decided to proceed on. Is that your understanding of the plan? It's a class A misdemeanor, which carries with it up to 1 year in the county jail and or a $4,000 fine, or both. Is that your understanding of the punishment range, so, of a class A misdemeanor?
Yes, sir.
Agreements have already been reached, you'd be pleading guilty, sentenced to 1 year in the county jail. That would be suspended. You would be placed on probation for up to 2 years. Restitution is owed in the amount of $3,000. How's that going to be paid and how quickly? You have a plan? How much can you pay a month?
I 500. I use, I'm pretty sure, maybe, all these guys, 60 months. 500 is much, definitely out of business.
All right, how do you plead to this lesser included class A misdemeanor, which is provided under section 162.032 subpart A under the penalty section, guilty or not guilty? Guilty. Are you pleading guilty voluntarily? And because you are guilty?
Voluntarily. I get here, so.
Yeah, that means you're doing it on your own free will, might put a gun to your head. Correct. Or something like that.
I'm just deaf.
You understand what free will is? Voluntarily.
Yes, sir.
Show you here what's marked as State's Exhibit 1. Did you sign that document?
Yeah, sure.
No. Understand it, discuss it with your attorney, or the contents are incorrect?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. The states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. You are guilty of the crime charged in any lesser included offenses, such as this one. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all through so help you God. States Exhibit 1, part of the record without objection for all purposes. Pre-sentence report is waived. Yes,
Yes.
I'm going to follow this agreement. And again, how do you plead to this lesser included? Guilty or not guilty?
Guilty.
And you're pleading guilty voluntarily and because you are guilty.
Yes, sir.
I'm going to find you are pleading guilty voluntarily. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this Class A misdemeanor of misapplication of trust funds under Section 162 of the Texas Property Code, Subpart A. I am following this agreement. You are hereby sentenced to confinement in the county jail for 1 year for this Class A misdemeanor. I am going to suspend that confinement, place you on regular probation for 2 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You, most importantly, must pay back restitution to stand by. The victim is not named here in the indictment. Who is the victim? Who is the victim? Do we know?
Second judge.
Okay.
Yeah, it's going to be the estate of Mr. Coon, Richard Coon. Richard Monroe Coon, COON. As full.
Okay. Richard Kuhn.
Yes, sir.
Is the victim in
Yes, sir.
this case. He's passed.
He's deceased. Yes, sir.
His estate is going to be the beneficiary.
Yes, sir.
The
The remaining restitution. Yes, sir.
restitution in the amount of $3,000. The defendant has stated.
Okay. Yeah.
The defendant has stated he can pay $500 per month, and that will be ordered.
Yes.
There will be other terms and conditions of probation that the probation officer will go over with you. If you fail, your probation could be revoked. And then you've already been found guilty here. So just, you're staying out of jail due to proper behavior and following the rules of probation. You could be sentenced up to 1 year in the county jail. So you don't want that. And pay these people back, the estate back. That's the right thing to do. Do you understand what has happened today, sir?
Yes, sir.
All right, please see the probation officer. Thank you.
It's the Courtroom Files Live. It's Monday. My name is Michael Groff, filling in for Dan Soul all week long. Yes. All right, let's head back up to Michigan. And let's go to a place we don't often go here. This is Judge Stacia Buchanan, and she's got her misdemeanor docket going. So let's see what's happening with her this morning.
Oh, curious what's going on. So glad you could join us, Ross. Are we ready to do some stuff? I know you were busy.
I feel like my obligations under the Crime Victims' Rights Act.
I get that. I just told the lawyers that we needed to have both sides of something in the courtroom at the same time. We weren't able to do that because Mr. Hardy's not in the room for the one with Mr. Abood, and then you weren't here for the rest, so we were stuck. Are we ready to proceed with Van Street then?
Do you believe we are? Yes, sir.
Bring your client, we'll call the case and see where we end up. On the record in State of Michigan versus Michael Van Street, 2500940 SM.
Property of the people. Bobby Strickland on behalf of Mr. Van Street. Good morning.
Good morning, and you're Michael Van Street. Still. Today is the date for jury trial, although we had set it over as a plea because it's my understanding there has been an agreement made. Is it the same agreement as before or a different agreement?
It is not the same agreement that you rejected.
Okay, then I'll take the plea paper and an advice rights.
Sorry, I didn't know we needed a. That's where it's for.
I think that's unique to my court. I'll take. give you the copy back. Thank you. Been handed a plea offer. This says Mr. Van Street is offered to plead guilty. It says with a 14-day jail cap consistent with the Cobb's eval, which actually the Cobb's was 14 days. It was not a cap. It was 14 days. And a recommendation of 7 days jail served on weekends.
And the agreement is a cap.
I see that. I think that's fine. You can make an sentiment of that being a cap. I'm just being clear that that was my Cobb's evaluation at that time. So unless additional information or factors are presented to the court. And then, of course, the recommendation is to serve the jail on weekends, and I've made no decision about that at all, of course. Is that a full statement of the offer?
Yes, Your Honor.
Mr. Ficklin, is that your understanding of the offer?
It is, Your Honor.
Mr. Van Street, that's your understanding as well?
Yes, ma'am.
And you're interested in accepting that today?
Yes, ma'am.
Mr. Van Street, as previously explained to you, assault and battery is a misdemeanor punishable by up to 93 days in jail and or $500 in fines plus court costs. Misdemeanors can carry up to 2 years of probation.
Yes, ma'am.
Some criminal convictions can have other consequences from the country, excluded from admission to the country, or deny naturalization as a citizen. You have the right to have an attorney in this matter, and today Mr. Ficklin is representing you. You have the right to a trial that could be by jury. Did you have an opportunity to review and advise the right to play information again today?
Yes, ma'am, I did.
Did you sign that?
Yes, ma'am, I did.
Have you had the chance to ask Mr. Ficklin all of your questions?
Yes, ma'am.
Do you understand that if you proceed with pleading guilty today, you will give up each one of these rights? There will not be a trial of any kind. Of course, you should understand that you have an agreement to a 14-day cap on any jail. So that means if I were intending to do more than 14 days in jail, you could draw your plea for the trial instead. But you should also understand there's a recommendation for 7 days jail to be served on the weekend. That's just a recommendation, and that does not bind me.
Yes, ma'am.
Lastly, you should understand that your sentence agreement to a 14-day cap could be forfeited if you engage in any misconduct between plea and sentence. So if you committed any new crimes or violated an order of no contact or failed to comply with any pre-sentence orders, you could forfeit your agreement.
Yes, ma'am.
If you were on probation, parole, or bond on the day this occurred and you plead guilty, you could be admitting a probation, parole, or bond violation. That could result in a consecutive sentence for your probation, parole, or bond violation. Also understand that if you proceed with pleading guilty, you'll be giving up your right to appeal things that you might be able to appeal if you were convicted at trial. Are you ready to proceed with plea today?
Yes, ma'am.
Raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth under penalty of perjury?
Yes, ma'am.
Mr. Van Street, on March 29, 2025, you at 1000 West Jolly Road.
Yes, ma'am.
That location here in the city of Lansing.
Yes, ma'am.
Was Randy Buck also present?
Yes, ma'am.
Did you strike Randy Buck that day?
Yes, ma'am.
That was with your fist?
Yes, ma'am.
In the face?
Yes, ma'am.
You understand by pleading guilty, you'll be giving up any claim that this was done in self-defense.
Yes, ma'am.
Additional questions on the factual basis today?
No, I would just know we ran into this last time. His name is Ryan Buck.
Oh,
I
that's
don't know why it says Randy Buck.
Because your office typed it wrong. That's your clerical error, sir.
Yes, I wasn't indicating it was the court's fault. Clarifying.
All right, Mr. Ficklin, anything else on the factual basis for you?
No, Your Honor, that's sufficient.
Mr. Van Street, did anyone make any promises or threats to you in order to get you to plead guilty here today other than this plea agreement?
No, ma'am.
Are you pleading guilty of your own free choice?
Yes, ma'am.
Find your guilty plea to be knowingly and voluntarily accurately made with sufficient facts on the record upon which to base your plea is therefore accepted. You already have your pre-sentence report done, but we have to give crime victim rights notice. So we have to set sentencing, but it doesn't have to be very far out, just long enough to give that notice. So like 2 weeks or so, whatever is open around that range. don't think I need that, so we aren't doing another referral. So I'm saying it's already done, so we're not gonna do that. Again, we just have to make sure the prosecutor has time to comply with crime victim rights act. All right, November 13, 1:30, you say? Yes. Okay. November 13, 1:30, Mr. Ficklin, does that work for you?
I'm checking now, Your Honor. I just want to double check something.
Just to be clear, sentences are in person in my court.
Yes, that's sufficient, Your Honor.
Okay. All right, then we'll get you a notice. Since you've already done your pre-sentence investigation, underpaid that work, of course, we'll just pull that report. It's pretty recent. And keep following your bond in the meantime. No contact with Ryan Buck, apparently. Anything else we need to address on our?
Nothing for people.
Nothing further, thank you, Your Honor.
Just have that court notice for you in a moment.
Thank you. Thank you.
Can I call Wilson so that Mr. Boone doesn't have to stay any longer?
Yes.
Appreciate it.
On the record in City of Lansing versus Michael Wilson, 210317480T.
Patrick Wood on behalf of the City of Lansing, Your Honor.
Assistant Public Defender Joseph Hardy on behalf of Mr. Wilson.
Thank you. Today's the date scheduled for jury trial. We did set this for 8 a.m. Mr. Hardy, you've been unable to look at your client.
That's correct, Your Honor.
We'll check finance. She's out now, right? This case is a little old. Mr. Abud, are you intending to continue to proceed on the case?
At this point, we do have it still open, and as our office's kind of attention, I think we still have an outstanding offer. If there is a, if there is contact made between defense counsel, with a hope to resolve this. It's not a decision I can make at this time.
Bench warrant and bond forfeiture. Thank you.
Thank you so much.
Mr. Green, do you want to go on the record with Mr. Williams? Bring your client up, we'll go on the record and confirm what we're doing, okay? Oh, no, grabbed the wrong file then, didn't I? Just kidding. Got it. Oh, I got confused. I think it's because my assistant gave me a jury verdict form for both. All right, here we go. On the record in state of Michigan versus Christopher Jones, 2501720 SM.
Ross March, being up for the people.
Thank you, Your Honor. Vince Greenberg, defendant Christopher Jones is standing to my left.
And you, sir, you're Christopher Jones?
Yes, ma'am.
Today is the date scheduled for jury trial. We're proceeding today?
Yes, Your Honor.
Yes, Your Honor.
Okay. The way this works, Mr. Green, I think you're familiar because you tried a case here not that long ago. We summon the jury. They have to come to court and get their orientation. So they're usually here by 10:30 and get a brief orientation, and then we commence with selecting. I guess I just want to confirm, do the parties expect this to complete in one day?
Yes, Your Honor.
Yes, Your Honor.
Okay. Should I pick an alternator or should we roll the dice with 6?
I think we should roll the dice, feeling risky.
If it's one day, I usually only pick 6, although it's just at the front of my mind what happened with Judge Flores the other day. So
What happened with Judge Flores the other day?
one of the jurors had a medical emergency in the middle of testimony and ultimately was removed from the jury, but they had an extra, so they kept going. But that's very unusual. That has not happened to me yet.
Your Honor, depending how many witnesses prosecution tends to call, I know my client has to pick up his children, what, about 3 o'clock or so?
No, today's jury trial day. He will be here until the jury, he needs to call someone and make arrangements. We are here until the jury reaches a verdict at least 5 o'clock, so. Okay, so what I'm trying to express to you, Mr. Green, of course, is that we will let you get a cup of coffee or something, but be back here about 10:30-ish. So when the jury's ready to come upstairs, we're all ready. Okay?
Sounds good.
All right, thank you.
It's the Courtroom Files Live, Monday, the 3rd of November, believe it or not. Less than 2 months to go in the year. Man, where's the time going? Michael Groff filling in for Dan Soul. We're in Judge Stacia Buchanan's court in Michigan. We'll hang here for a little bit longer, and then we've got a bunch of other places we can go. Just kind of interesting to see what's happening here. We don't often go to Miss Buchanan's courtroom, so we'll kind of hang out and see what's happening if there's anything else going on. If not,
Are we ready
well,
to
we'll
go
see.
on the record?
We'll see where else we can go. But back to Judge for now.
Williams, right?
Yes, I am on Williams.
Are you ready?
We're working on paperwork right now.
Okay. All right. What about, I don't know if this is yours or yours, Mr. Carter, are we ready to go on record? Mr. Carter?
Yes, Your Honor.
Okay, Mr. Carter, come join your lawyer. On the record in State of Michigan versus Marcel Carter, 2502496 FM.
Ross Marchmina for the people.
Yara Khalil on behalf of Mr. Carter, who is standing to my left.
All right, are you Marcel Carter? Today's the date for trial. Have we decided what we need to do?
Your Honor, we would still be proceeding with trial.
Okay. You as well?
Yes, Your Honor.
Okay. Before we let Mr. Carter have a new date, I just want to confirm that there's no reason to think we're going to call in a jury on Mr. Green's matter and then not be ready to proceed on that. That's going for sure, right? I can give Carter a new date without worrying that my jury today is going to be wasted.
Yes, Your Honor.
Just making sure. You know how much of a time and effort goes into bringing a jury. So gotta make sure we use our time efficiently.
The next date that is not currently blocked off is December 8th.
Okay. All right, I'm sorry, Mr. Carter, that you weren't the oldest trial today. So unfortunately, if another trial is going, I have to give you a new date. So that'll be December 8th at 8 a.m. We're going to give you that new court notice in just a moment here so that you can be on your way. Remember to continue to follow your bond, including your no contact order with Ms. Bauer. If you violate that order, you could be arrested without a warrant. This bond could be revoked and you could be in contempt of court, for which you face 93 days in jail and or $7,500. So don't make any bad choices. Okay. Thank you.
Is it me or does Judge Buchanan's court have the loudest staplers and hole punches of any courtroom we go to? Just a random observation.
Doyle, are you ready to go on the record with Ms. Miller?
Yes, Your Honor.
I see that. And you'll be ready to go on December 8th as well, right? Every day in between. Okay, on the record in State of Michigan versus Kanika Miller, 2502327 SM.
Ross Marchmina for the people.
May I please court Dan Doyle on behalf of Mr. Miller, who's present standing to my left.
And you are Kanika Miller.
Yes.
Today's the date for our jury trial. What's your status?
Your Honor, the people would like to know this case due to lack of contact with the necessary witness.
Okay.
And we have no objection now.
The witness was here back on October 20.
Well, the
and then
witness was
ghosted you?
here for a pretrial on his own case.
Oh.
So,
I know what you mean. Okay, Ms. Miller will get you that no contact or I'm sorry, the dismissal. But if the witness gets a hold of the prosecutor, convinces him to reissue, that can happen within the statute of limitations. Also, please understand that it does take time to get the no contact order out of the police computer. If you have contact before you've done that, you risk being arrested. Further, even if your no contact order is lifted, I can't remember if he still has one.
Yes,
If you two keep getting each other in trouble, probably best to try not to have a lot of contact. Because I don't need to see both of you.
Please, I understand.
I'll have my court officer make you a copy to take with you of that.
All right. It's the Courtroom Files Live. It's Monday. Pretty quiet in Judge Stacia Buchanan's courtroom. But we will, of course, check back in there. Sounds like she's got a jury trial going later on this morning. I don't know if we're going to... We don't normally show jury trials here on TCF Live because they're usually pretty involved and whatnot. Interestingly enough, right now I'm watching Judge Brantley Clark's court in Florida. He's got jury selection, kind of the voir dire process going on. Maybe we'll kind of check in on that. We've got a number of other courtrooms that are got some action going on. But I suppose where we can go next, what do you say we check back in with Judge Stevens?
You swear all claims to tell the truth and nothing but the truth, nothing but?
Yes, ma'am.
Okay, you got your right now. Collaboration on the law.
Also, Barbara, thank you for the $10 super chat. Really do appreciate that.
And right here.
I've got the poetry going this morning.
I need to file. So 25 CR 791 is now called Thomas. Is it Foy Wayne Smith?
Yes, sir.
That's good long name. You were here with your attorney, Mr. Deucer, and the state's attorney does the defendant willing to a formal reading of this indictment and arraignment. Can we proceed in summary? Yes, sir. In summary, this indictment alleges, sir, that on or about April 29th, 2025, in Jefferson County, Texas, you committed a third-degree felony of unlawfully possessing a firearm by being a previous convicted felon, as you were convicted in November of 2020 in Orange County, the district court there, for robbery. This is a third-degree felony that carries with it, if convicted, no less than 2 nor more than 20 years, no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range for a third-degree felony such as this?
Yes, sir.
An agreement's been reached in your case. You would be pleading guilty, sentenced to 5 years in prison. Is that your understanding?
Yes, sir.
If
I wanted to hire a lawyer, so I didn't know he was gonna be here.
Who's he?
Right?
What about it?
Oh, well, hired him. I didn't know he was gonna be here. He showed us. Oh,
Well, he's your appointed lawyer. Have you hired him yet?
no, sir.
Well, he's still your lawyer until. What are we going to do today?
We're going forward with it today.
Like, I'm following the agreement that y'all reached,
Yeah.
but
All right.
what do you want to do? So,
I guess we'll go with it.
is that your final answer? Yes?
Yes.
Okay. All right. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes.
I'm going to show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Understand it, discuss it with your attorney. Are the contents all true and correct?
Yes.
State's Exhibit 1 tendered into evidence without objection admitted. Among other things, the states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The documents been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with your attorney according to this. So help you God. Correct?
Yes.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is.
Yes, sir.
I shall follow this agreement, sir. If nothing further, I will find you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony, of unlawful possession of a firearm by previously being a convicted felon. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for all time you have served in accordance with this case. Do you understand what has happened today, sir?
Yes, sir.
Anything else?
No, sir.
That is all. Thank you. I have a case on Sonia Road. And on Sonia Rose, is that the only case that was there?
Yes, sir.
It's okay. Any reason the court should not sign this dismissal? 37778. It is hereby dismissed.
Just tell everybody here, you know, meet any of us. Nice little go away. Hello.
And I've got Michael Pete.
What's an add-on judge? You can.
Here's this one. Here, these two.
I'm guessing we need.
Who is it? It is Pete, Michael Pete.
You'll have to get.
Two first names.
It's a plea on 1 and 2 dismissals, Your Honor.
Okay. I've got 3 cases. You need to see him, right?
Yes, please.
Sir, please, she's going to get a fingerprint from you. Yeah, so swear you.
Mr. Beach, please raise your right hand.
Which one is it pleading to?
Theft of a firearm.
You've got your right hand.
Oh,
718.
yes,
I'm trying to get to it.
The other 2 to be dismissed.
yes.
Saw which document?
This was an add-on, Your Honor.
Add on?
He asked me if he wanted me to take care of it. You're gonna call it mine.
3 cases are now called 24 CR 718. Michael Pete, that's you. And then there are two other cases, 1688 and 24 CR 1688 and 25 CR 908. I did believe those two are going to be dismissed based upon your disposition and plea entered in this state jail felony of theft of a firearm in 24 CR 718. You're here with Mr. Turk, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here?
He
Can we
does.
proceed in summary?
We may.
Let me see the computer will finally. This is currently being used by somebody else.
Right now.
There, it's working now, I think. Maybe.
Man, there's a lot.
I just missed. What was it said today?
Okay. On these. Which paragraphs are we proceeding on? We got one, and then what else?
I believe 2 and 3.
So was that not on there?
It's-
And that constitutes a state jail felony, punished though as though it were a third degree felony.
Right.
All right. 211, 211 are on the same date. That ought to work. Could have been enhanced to a second degree felony, though, right? Okay, we're not doing that. We're going to just do third degree felony. All right, sir. When he's waiving formal reading, we can proceed in summary. In summary, paragraph 1 alleges that on or about March 1st, 2024, in Jefferson County, Texas, you committed the state jail felony of theft of a firearm. Do you understand what you're charged with here?
So
Paragraphs 2 and 3 go on to allege that on December 5th, 2011, you were convicted in the 252nd District Court of Jefferson County, Texas, for state jail felonies of controlled substance and solicitation of minor type of offenses. Paragraphs 1, 2, and 3 constitute then a state jail felony, punished though as though it were a third degree felony. Which means we're gonna write all this down. Asterisking at the back to the bottom, okay?
New range of punishment.
we talked about.
Yeah.
All he's doing is adding on the state jail, but the state jail, state jail's range, since it's going to be punished as a second degree, he's added a 10. First page, that your initial, that's what he's adding. You just want to switch it on. No names. Right. Well, it's a state jail felony, but the punishment's 2 to 10. Yeah. I'll be right there.
You were facing not less than 2 years prison, nor more than 10 years in prison, up to $10,000 fine for a state jail felony punished as a third degree felony. Do you understand, sir?
Yes, sir.
And an agreement's been reached in your case where you would be pleading guilty, sentenced to 3 years in prison. And two other cases would be dismissed. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
So how do you plead to paragraphs 1, 2, and 3 of this indictment, sir? Guilty or not guilty?
All the reasons are good.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraphs 2 and 3, those prior convictions of in 2011 for controlled substance and online solicitation offenses out of the 252nd District Court of Jefferson County, Texas. Are those true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those allegations voluntarily and because those allegations are true as they are alleged in the indictment?
Yes, sir.
I will now show you what's marked as State's Exhibit 1. Did you sign those documents? Understand them, discuss them with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1, tendered into evidence without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea as freely and voluntarily. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
States Exhibit 1, made a part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
You know, make this 3 look like a Arabic 3.
That's.
I do that. We used. It looked like a snowman.
Actually, a lot of, I like this because Arabic really does not.
I didn't want that to look like an 8. Which I'm going to find, sir, that you were pleading guilty to paragraph 1 and allegation 1 in paragraph 1 of the indictment, the state jail felony substantive crime here of theft of a firearm, and paragraphs 2 and 3, the 2 prior felony convictions. In 2011, you are pleading guilty and true respectively to paragraphs 1, 2, and 3 voluntarily, knowingly, intelligently of this indictment. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea and pleas of truth from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this state jail felony. Punished, though, as though it were a 3rd-degree felony because of the prior convictions. I now find you guilty thereof. I am following beyond a reasonable doubt. I am following this agreement. You are hereby sentenced to confinement. It says confinement in the state jail for 3 years. As you know, that can't be. Confinement in the institution, in prison for a term of 3 years. I'm going to change this. Do you understand what has happened today? Yeah, when you use these, a bunch of changes have to be made.
Sorry, it's just because I figured since it was just a milkshake.
All right, do you understand what has happened today, sir?
Yes, sir.
All right, good luck. You will be given credit for all time. You have served in accordance with this case, okay? And it will run with other cases unless otherwise ordered. Stand by. Ah, darn it. That's not what I want. Okay, this is Mr. 17-8, Mr. Pete. 1688 on Michael Pete. This is before the court. That is dismissed as part of this agreement. If you touch this with your hand, it makes marks and smudges. That's why I use this thing on. 2025, and this is what we're doing. God bless you. Bless you. And 25 CR 908 is before the court, and that one as well is hereby dismissed as part of this agreement. That is done. All right. Good luck, sir. That was all.
Will someone please get those folks in Jefferson County new pads? Man, they've been complaining about those iPads, those tablets, whatever, in Jefferson County seemingly forever. My goodness. TCF Live, it's a Monday. It's obviously a Monday everywhere, and seems really very much so down there in Jefferson County. All right, speaking of Texas, let's check in with Judge Boyd. It's been a while. Boy, oh Boyd. Let's see what's happening with Judge Boyd this morning. Oh, by the way, Barbara, thank you for the gifted membership in the chat. Really do appreciate that as well. And it went to Win, who's active, who participates in our chat from time to time. We haven't heard from Win in a while, but nice gifted membership. They are random, but always good to see that. So again, thank you, Barbara, for the membership. All right, let's check in with Judge Boyd. All right. All right. Well, I thought it was Judge Boyd, but apparently it is me that's having the audio issue there. Let me fix that. My apologies. I know it's a very professional operation, but this stuff, sometimes it breaks right in the middle of a fine broadcast like this. Like I said, it's a Monday, folks. It's a Monday. We're going to get you that, though. We're going to fix that up for you. There we go. Judge Boyd is back and better than ever. There we are. Thank you.
Elizabeth Morgan.
Morning.
Morgan. Found party is announced for the record.
Michael Dwight Goins for the defendant, Your Honor.
And are you Natasha Elizabeth Morgan?
Yes, ma'am, Your Honor.
All right. Did you review the motion to revoke community supervision with your attorney? Did you understand it?
Yes, ma'am, Your Honor.
Are you the same Natasha Elizabeth Morgan who was placed on community supervision in 2024 CR 1225 for the offense of robbery on July 2nd, 2024 for a term of 10 years? Is that you?
Yes, ma'am, Your Honor.
State.
Violation of condition number 4 of Adair County taxes, the defendant Natasha Elizabeth Morgan did then and there fail to report to the supervision officer as directed for the months of July, August, and September of 2025 and violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
And we leave and abandon the remainder.
No objection, Your Honor.
All right. Did you understand by pleading true to violation of condition number 4? The court could find it true, grant the motion, and sentence you up to 10 years in the prison and up to a $500 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, it's for court to grant the state's motion to revoke the defendant and reform from judgment to reflect a 6-year term in prison.
That's correct, Your Honor.
All right. Are you asking the court to follow that agreement?
Yes, ma'am, Your Honor.
Are you waiving your right to appeal?
Yes, ma'am, Your Honor.
All right. Probation. Was there any restitution to the complainant that was due?
So, Judge.
Then the court will follow your agreement, sentence you to 6 years in the prison, give you credit for any time served. There's to be no residing in households with minors and no unsupervised contact with minors. Thank you, State. You may be excused. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am, Your Honor.
Did you understand it and sign it?
Yes, ma'am, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea. And because you would like to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am, Your Honor.
All right, we can go off the record. So what happened? Why couldn't you successfully complete this?
Well, Judge Boyd, just be honest with you, I couldn't do it no more. I didn't have an address. I just gave up.
All you had to do was come in here and talk to me or either call probation.
No, I thought about it.
Yeah. All right, well, good luck to you, okay?
Yes, ma'am.
I be excused, Your Honor.
Yes.
Thank you, Judge.
Yeah.
Have a seat, ma'am.
You don't want to give up on probation just because you don't have an address, because, you know, Judge Boyd, of all people, is the judge that you can go and talk to about your issues with probation.
All right, anyone else ready?
So we'll hang out here with Judge Boyd if she has another contestant ready to come on down. Otherwise, we've got other places we can go. TCF Live, it's a Monday. We're in Texas with Judge Boyd.
All right, Akira Santiago.
Yes, sir.
Thank you. Cheers. All right, Miss Santiago, if you could unmute, please, and show your video.
Can you hear me?
You judge, you're welcome. All right. So in this case, where are we on discovery?
I think we're good with discovery.
Okay.
I feel like I have everything I'm supposed to have.
All right, did they tender an offer?
They are doing that right now. They're looking it up to see what they want to offer us, so I can communicate that to my client.
All right, and Miss Santiago, how old are you?
I'm 21.
All right. What we're gonna do is we're gonna reset this in 30 days.
Okay.
And that will be her plea deadline date,
Okay,
and she can appear by Zoom. If you decide to have a jury trial, it will be in the new year.
and just so the court is aware, it's my understanding that she is 5 months pregnant.
Okay,
Just wanted to let the court know.
all right. So we'll let her appear by Zoom, and we will recall it for December 18th.
December 18th, I have it.
All right, Norma, on Akira Santiago, she can appear by Zoom, and we'll recall it December 18th, and it's a plea deadline date. All right. Is there anything else, Miss Santiago?
No, thank you.
All right, and is she out of state or out of county?
She is out of state. She's in Arkansas.
Okay,
So I will communicate with her, whatever the state's offer is, and we'll make a decision before coming back.
all right, thank you.
Thank you.
All right, thank you, Miss Santiago, and thank you for dressing appropriately for court, even though you're by Zoom. I appreciate that.
Thank you.
All right, anyone else ready?
We have a sentencing judge. Good morning. Happy
Good morning.
birthday.
Oh, thank you.
I need to speak to you for you.
And Norma, do you have the motion to have the guy brought over from? And Deputy Laura, if you can tell them to expedite Mr. Savage. What page is he on? Savage.
Page 1, bottom.
Thank you.
All right. Well, we wait for the next contestant to come down. Thank you again, everybody, for joining us. TCF Live. It's Monday. Hang out in the chat with us. A lot going on in the courts this morning. We do have some other places we can go, and we will be going to through the morning hours. But we like to check in. It's our commitment here to give you 9 to 11% more Judge Boyd. And she has a contestant that's coming on down. So we want to, I was trying to push it forward a little bit in the Wayback Machine, but maybe while we wait for that contestant to come on down, let's head back to Michigan. Let's see what's going on with Judge Shackelford.
All right, I'm looking at this on 251660 FY, the people versus Gavin Bruce.
Good morning, Your Honor. Alyssa Segura with the Neighborhood Defender Service, P86432, appearing on behalf of Gavin Bruce, who is present via Zoom. Mr. Bruce, will you please unmute your device and state your name for the record?
Gavin Bruce.
All right, Ms. Segura, can you I see that we're resetting it just for an exam. It was remanded for just a limited purpose of an identification issue. Is that correct?
That is correct, Judge. This case was bound over to circuit court after a motion to quash and a motion to suppress. The case was remanded back to district court. I believe there is an officer that the judge indicated would have been a better fit for identification purposes in this case. And I can't recall the officer at this time, but I did inform Madam Prosecutor that I will review the discovery and send her that name. Also too, because I am missing the body cam footage from that officer, which I think is really crucial in this case. So I'll submit that to a request for that discovery.
All right, so was the entire, are we holding an examination or is it just the testimony of one witness for this limited purpose?
Yeah, just the testimony of this one officer. I don't think we need to kind of redo the entire exam. There's just, I believe, some testimony that was from the both complaining witnesses that the court would be instructed not to consider for the identification purpose, because the judge did find in circuit court that the identification of Mr. Bruce as the person who committed the crime, basically that they could not have identified him. That he found that it was unduly suggestive and inadmissible.
All right, so we're just setting the exam for, or do you need a PCC because you need body cam, or are we ready to just set this in maybe 2 weeks?
If we could set it for the 24th, I think that would give Madam Prosecutor enough time to request the necessary officer and then get me that body cam footage. If we want to come back for a PCC on the 17th, just to ensure I have everything, that's fine with us. But I don't know if I'm physically going to be in town on the 17th. So the 24th would work if that would work for the court.
All right, this is what we'll do. We'll set a PCC for 11. You can do the 17th for a PCC though?
Yes.
11, 17th. What time, Ms. Segura?
Anytime works for me, Judge.
All right, let's do it. All right, is that all? Oh, you have a bunch of stuff here that day. No?
I don't think so.
I have one sentencing. It looks like I have Dakari Gatewood.
Yes, the sentencing.
All right. That's at 8:30. We'll do this at 8:30 for the PCC on the 17th. That way you're here at the same time on both cases. You can appear on Zoom for that date. Mr. Bruce, Mr. Gallup, and then the exam on 11/24 at, let's do 10:30 a.m.
10:30, Judge?
Yeah, and you've talked to counsel about who she needs here?
I told her I would email her the name of the officer as soon as I get a chance to look over the discovery again later today.
All right, great, thank you.
Yeah.
And we're all set for today. That concludes the hearing and bond continues.
Thank you, Judge.
Yeah.
You're all set, Gavin.
Oh, you guys have a good one.
You too.
Yeah. And Mr. Gallup, you're all set for the day. Did you speak with the Miss Dennis or have you spoken with Mr. Gallup?
I did, but I can go in the breakout room to explain what you said to both victims, Lambert and Gallup.
All right, it's just a technical legal issue that the circuit court wants us to clear up. Okay, but do you want to go in a breakout room with Miss Dennis? All right, I'm going to put you back in, okay? All right, Mr. Strauss, can you come on up? And Mr. Strauss, I don't want you to talk to me too much because your attorney's not here, okay?
I just want to say good morning.
Good morning. Okay, so it's my understanding we're here today for a probable cause conference. You were to appear in person, and I think that was because you might have had some difficulty with Zoom, and your attorney was allowed to appear via Zoom. I was advised by the court officer that your attorney had contacted the court today and indicated he was
We might
ill.
have to send it down again,
So,
maybe.
Mr. Gallup, join that breakout room, okay? Because you're in a courtroom, and you're not muted. All right, so I know that you indicated, or my court officer just told me you had tried to reach out to your attorney who wasn't responsive. He contacted us, or somehow we received notice that he was ill today. So today was a probable cause conference. We have an exam set for next Monday at 10 a.m. and absent some change, I'm going to, sorry, your attorney sending in some sort of notification. I'm going to assume that exam is going next week.
All right. The dates, I'm not driving anymore, so I do have to.
It'll be in person next Monday.
Yeah, I'll get here.
At 10 a.m. And I know we also have a complaining witness present in the court. Is that correct? Ma'am?
Oh, yes, we were hit by the defendant.
Okay.
Received a notice
Okay.
to appear.
Okay. Have you spoken to an advocate? Is Miss Dennis here in person? All right. She's on Zoom. Okay. There's a prosecutor out there that you can talk to briefly. We're set for exam next week, November 10th at 10 a.m. But make sure the prosecutor can get a hold of you in case something else happens. So you don't have to, because if it's just a hearing like today, you can come on Zoom. The only day that you need to come in person is the day they take testimony. Okay, which is supposed to be next Monday, but we don't have the attorney here to know whether or not that's still the plan. But you can talk to Miss Sobe out there, the prosecutor, a court officer can show you where she's at and just make sure she has contact information for you. So you can be apprised as to whether or not that date will still be next week. Okay? Yeah, they'll show you. Okay? All right. I'm assuming we're proceeding to exam. Absent, hearing otherwise. Okay?
All right, Mr. Strauss, you're good to go. Sir.
All right, we're all set.
Okay.
You grade your stuff? It's next Monday at 10 o'clock.
That's it for now.
All right. That's what's going on up in Michigan. Judge Shackelford, a lot of procedural sort of stuff happening. It looks like Judge Boyd has the contestant coming back down, so we can finally go out here and see what's happening with her. Oh. Looks like we don't have audio. Well, I have audio. You do not have audio. So that keeps happening. Stuff breaks. We will get you this. All right, let's get back out here. Oh my goodness. It's a Monday, folks, here at TCF. Luckily, this is why we have the monitor. This is why we have everything installed here. You'll just have to forgive me while we get you back out here. All right, for realsies this time. For realsies, let's go back to Judge Boyd and get this. This might be a sentencing. I don't know, or a plea.
Could I have
Let's see.
parties approach and announce for the record?
Attorney Bill Simmons for defense.
I'm so sorry. How do you pronounce your first name?
D'Artagnan, like the Three Musketeers.
Okay, D'Artagnan, reason.
Yes, Your Honor.
Yes.
I still have yet to watch the movie.
Oh, you need to watch the movie.
I think I'll read the book.
Okay. All right, we're here for sentencing. You entered a plea on September 9th, according to the plea bargain agreement. Punishment is to be assessed at $1,000 fine. The state recommends deferred adjudication. They're taking in consideration 2025 PF 20245. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
Yes, Your Honor.
Any objections?
No, Your Honor.
No, Your Honor.
All right, anything you wish to say on behalf of your client?
No, Your Honor. We think the PSI speaks for itself. He has had some issues, but he did take full responsibility. He knows he could have done things differently, and we pray that the court follows the plea agreement.
All right, anything from the state?
No, Judge.
All right, state, you may be excused. All right, so what were your issues on this day?
Not too sure.
Well, I mean, they're recommending that you be placed on the mental health caseload. And I know there were previous hospitalizations for him. So are you current on your medications?
For severe ADHD.
I'm sorry?
No, not for the severe ADHD. I have some from college when the doctor prescribed some left over, but I don't take it on a daily.
Okay, when's the last time you saw a doctor?
Since I came here to college, put myself through college, I haven't been able to get healthcare really.
Okay. Because it seems to the court, and correct me if I'm wrong, counsel, that there is mental health issues according to the PSI report.
According to the PSI, Your Honor. Oh, I'm sorry, Your Honor. I didn't mean.
No. So he needs to figure out how to obtain his medications, because otherwise there may be issues for him. And it appears that part of the reasons for this happening, and the reason I'm assuming the state offered him deferred adjudication, is because of mental health issues.
Yes, Your Honor. And the PSI, I believe, addresses the Genesis program. I also conferred with probation as it relates to kind of the ins and outs of that program.
Mhm.
And I also discussed that with Mr. Reason, anticipating that the court would probably pick up on that. We don't have any objections if the court were to order him into that caseload, Judge.
All right, and are you living by yourself?
Yes, ma'am. I just got my first apartment.
Okay. And do you have any family support here or no?
I came to Texas in 2018 and put myself through college and leave Detroit. And I've just been doing life on my own since, trying my best.
Okay. Ms. Abrams, what do you suggest? We have some mental health issues and he's not on medications because he doesn't have health care. And you all are recommending the mental health caseload. Should I also refer him to Center for Health Care Services or? Okay.
I asked the probation officers for resources to help me with like food and things like that, just to help me set myself up for success.
Okay. And
I
are
got those
you,
resources.
so you have an apartment, are you employed?
Yes, yes, ma'am.
And what do you do?
I am a sales associate. I used to, before this, which I'm hoping to go back to, I was a supervisor at the airport for plane refuelers.
Okay.
It's pretty fun.
All right. The court is going to sentence you to 1,000 reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. Taking consideration 2025 PF 20245. 4 years deferred adjudication. 200 hours of community service restitution. No possession or ownership of any animals. The MIC caseload. Field visits 1 time per month for 6 months. Probation. Is there anything else that's recommended?
Definitely.
All right, when you see probation, you need to make sure that they know that you need to seek help with Center for Healthcare Services. And I know they'll do it, but you know, sometimes people forget.
Yeah.
Sometimes things fall through the crack. And how do you spell your last name?
Reason, Reason.
All right, so the record will reflect that the last name is spelled Reason, not Reeson. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you.
And happy belated birthday.
Thank you. Oh, it's not belated. I celebrate the entire month, but I appreciate that.
Your Honor, did you have a rejection form?
Yes,
Maybe it's you.
yes.
All right, it's the Courtroom Files Live. It's Monday. I suppose we'll just keep on doing this Texas two-step. Take you over to Judge Stevens as he's got the next litigant on their way in. Next defendant. Okay. Not again. Well, every time we switch it up here, we get an audio issue now. Well, again, Michael Groff filling in for Dan Soul. I'm sure you'll be more than eager to have Dan back in the chair next week. He will be at his fine studio, not Studio B. That's where I do this from. And obviously, we hold things together here with razor wire and duct tape, and it's quite the situation. But that's how it is. Let's get you now to Judge Stevens with audio this time. There you go. Thank you.
Mr. West, your attorney and the state's attorney does, what are we going to do? We've got two cases. He's going to be pleading to
The obstruction and retaliation.
1758,
Yes.
and then 1756 is to be
I
stand by.
think 1756 is a plea and 1973 is a dismissal.
Okay, there's just two. 1973 to be dismissed.
Yes.
So in 1756, does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes,
We
please.
just go on to paragraph 1. There's a second paragraph that enhances. Is it a third-degree felony?
It's up to the state. I mean,
What's the deal?
it's just all, we don't need to count two, Joe.
Just on paragraph 1, Your Honor.
Okay, so it's been checked off, second degree.
We need to go to third, right?
Right? That's what everyone wants to do.
Good for us.
All right. The secret is in the sauce and the penalty. Deferred or unadjudicated. It's up to 10 years in third, second, and first, but that's what happens if his probation is revoked. It makes all the difference in the world. But y'all are agreeing for 10?
Oh, I'm happy with that.
Third degree
That's
felony?
okay with that. I'm okay with that.
All right, then we'll proceed. He waives formal reading of the indictment. We can proceed summary in paragraph 1.
Yes, sir.
Paragraph 1, sir, alleges that on or about June 18th, 2024, in Jefferson County, Texas, you committed the third-degree felony of obstruction or retaliation. And that is intentionally or knowingly threatening to harm a peace officer in retaliation for their status and acts as a public servant. Do you understand what you're charged with?
Yes, sir.
And this is a third-degree felony, and you are Chaz Wayne Kyles.
Yes, sir.
A third-degree felony means if convicted, you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement's been reached in your case. You would be pleading guilty, placed on deferred or unadjudicated probation for 10 years, and another case would be dismissed. 1973. Is this your understanding of the agreement?
Yes, sir.
If I follow this, sir, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'm going to show you here what's marked as State's Exhibit 1. Did you sign on this document, understand it, discuss it with your attorney, or the contents are incorrect?
Yes.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. That's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by Mr. West, your attorney. All of this is true, so help you God, it states.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Is a pre-sentence report what?
Please, Your Honor, yes.
Sir, I will follow this agreement if nothing further. I will find you are pleading guilty voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty, even though there's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here. That would find you guilty beyond a reasonable doubt of this third-degree felony. I am instead deferring or postponing any finding of guilt so long as you follow these terms and conditions of probation we're going to be dealing with here. And you will be seeing the probation office and going over with these and then signing, promising as a contract. You will follow these terms and conditions of probation. Most of these are the same things I have to follow without having an indictment over my head. So it's not something that's going to be impossible. Do the right thing. you will be placed on deferred or unadjudicated probation for 10 years. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 10 years in prison, which you don't want. So fix this. You do well, it can be shortened to 1/3. 1/3, I could dismiss this, which is 3 1/3 years. You can almost see the finish line from here. You do. All right, I've signed the documents. Here's the handing to the probation office. You're gonna promise to do well on this?
Yes, sir.
Good for you. Part of this plea agreement, the case will be dismissed. Yes, sir.
Should be on the tablet, Judge.
Well, it's not on the tablet, it's inside the tablet. Just a matter of some semantics. You know, what did I hear once? The difference between semantics and some antics are hardly a difference. Sometimes. I made that one up.
I see that.
I think it's an interesting thought.
95% statistic
For
on
those-
this one spot.
For those who think. The deep thinkers. Is Miles Horn here? Miles Horn? Is he in custody or in? No, it's a bond hearing, so he must be in custody. That was why I'm just. Lori,
Yeah.
Brian Henry. Two cases, right?
Yes, sir.
Where are we?
He's in custody.
We need him out, Brian.
Yes.
Yes. Okay.
Who for calls other case, Judge?
Here we go. Give that to you as a souvenir.
Right.
Brian Baker.
Here, look at me.
Oh, what am I doing with these?
That's the problem I'll be eating out. Judge.
It's. Here, yeah, here, I'm gonna give this one to him. Tragic waste. Brian David Henry is called next 25 CR 1327 and 1328. The defendant is charged in each case with the first degree felonies of continuous sexual abuse of a child under 14. If convicted in each of these enhanced first degree felonies, we're looking at no less than 25.
Yes, sir.
No less than 25 years in prison up to life imprisonment. I don't believe there's a fine on these. So it's 25 to 99 years confinement or life imprisonment. Also, the parole on this is day for day, isn't it?
That's correct.
So the minimum sentence is 25 years, and if sentenced to the minimum, the defendant would have to serve 25 calendar years before he would be released. So let me look at the thing here. These are not two separate events with the same child. These are two separate children younger than 14 years of age alleged to have been victimized, correct?
That's correct, Your Honor.
All right. Is there any other enhancements there?
I don't think so, Judge.
It's,
I'm aware, Your Honor.
it's, no,
I haven't seen any
1327
prior
looks like
history.
it alleges.
That's actually the count of the number of conduct for the continuous.
19 separate methods of committing the crime alleged in one of them. And 1327. That's what it alleges. It's what, and then the other ones. 8 allegations of criminality in 1328 of that child. Now, the defendant lived in Newton County, but these all occurred here in allegedly in Jefferson County, Texas, correct?
Yes, sir.
The age of the children, I don't see how.
16, and the other one is over the age of 18.
Couldn't have been at the time.
Not at the time.
No, I'm talking about the time of the event.
Well, that's
Do we,
let's see.
5 for one,
6,
and 11 or 12 for
It's
the other.
allegedly December of 2015 and 1328 and on or about December in 2016. So what would the ages be?
Years for one and 11 or 12 for the second child.
Okay.
Which is the one alleging 8 separate offenses.
The female, it's the female.
That's correct.
Okay. Today, what are we doing?
So we have a bond hearing or a bond reduction hearing scheduled for today.
Okay, stand by.
Certainly.
Public safety.
Safety report. A safety report. I don't think he has one.
When there's a bond here, I have to have a public safety report now, as law requires, so the court knows if there's any other criminal history, among other things, that the public safety report reports. But while we're waiting, go ahead.
Yes, sir. So I have filed a motion to reduce
The bonds are
the
what
bond,
right now?
500,000 each.
In each?
Yes, sir. In my motion, I have requested that the bond each be reduced to $25,000. Or that he be released on his own personal recognizance. And
I'll see that. Let me move back.
Keep going. I'm with you.
And Your Honor, if the court so requires, for the defendant to be released, we're asking that he be ordered to wear a GPS or global positioning system monitor tracking device. He is from Newton County. He lives and has resided in Newton County for several years, as well as Jefferson County. He has ties to the community in that he's always resided in the area. was currently or was employed at the time of his arrest. And there's been no evidence that he would abscond from justice or would not appear. And these are allegations, Your Honor. They have not been proven. There are a lot of factors at play here in this case that the court is unaware of.
I see.
So. Your Honor, Mr. Henry also suffers from a physical disability. As you can see, he's confined to a wheelchair because prior to his incarceration, he has to wear a leg brace.
What?
Well, he can't walk without his leg brace.
And so what's the point? Though? I mean, everybody has a disability of some sort.
Using that as an excuse or a reason for him to be released, but clearly he has that would also hinder him from absconding if, in addition to him wearing a global tracking device.
Although the grand jury has in its allegations, it didn't hinder him from allegedly committing two of the most serious types of crimes that the state penal code has printed and determined are punishable.
Jones.
I understand, Your Honor. Still,
These his children.
I'm sorry.
These here.
One is the biological daughter and the other is a stepdaughter.
Your Honor, may I speak?
Just a second. You've got a chance to speak here in a minute. Anything else that you want to add?
Your Honor, Mr. Henry's wife is present as well in the courtroom, Jessica Morales. And she will also ensure that he makes it to court. She understands as well as Mr. Henry that these are very serious allegations. It's every intention of his to appear for every scheduled court date. And I believe that due to the amount of the bonds, it's unreasonably
I've
high.
seen a lot higher.
I understand the court's position on that, but and a man of his position, he's unable to make bond at those amounts. And I believe that he's entitled to a reasonable bond.
I think that's true based upon the provisions that the laws provide for, and not everybody gets a bond that they're able to afford.
And Mr. Henry doesn't have a record. He was, prior to his arrest, gainfully employed, productive citizen. And again, these are allegations, and I don't want to argue the case, but everybody is innocent until proven guilty.
Unless proven guilty.
Sorry. And we just believe that he should be given an opportunity to make bail so he can continue to provide for his family and go back to work.
Stay.
Judge, this is not an unusual bond for these type of offenses we've had in this court. And looking at the ages of the children at the times, the amount of actual contact he had that's alleged in our indictment.
What are the ages of the children at the time it is alleged that he sexually abused them?
But she stated, Judge, that they were, one was 11 or 12 and 10 or 11. The other one was about 5 or 6, depending on the age group, because there were several years involved.
In each of these cases, it's alleged there were multiple acts.
Yes, sir.
What quantitatively does the state understand? How many are we talking about?
Well, each one has its, as the ones we've alleged in the indictment. So we've got the 8 of the one, and I think over 12 to 15 of the other. So every one of those is an incident. So we've We think the bond is fair. We think for the, not only for the safety of the victim, safety of the public, but this man may not run normally, but this is 25 to life and he's facing a lot of time without parole. And so we would think just to ensure that there's no contact, no safety issues with the victims, since they were family members, that we would ask for the bond to stay at 500,000 on each one.
All right. Anything else you wanted to add?
I think that Mr. Henry would like to say something.
You want to say something, sir?
I would, Your Honor.
Hold on, raise your right hand. As best you can, do you solemnly swear or affirm any statements that you are about to make shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Lower your hand, go ahead.
If you will allow me to make a bond, I'm not gonna run. I mean, if they would have called me, I'd have brought myself to them and thrown myself in. I don't run. I'm innocent. I did not do this.
Well, you can imagine everybody says that who's in here, and you have a presumption of innocence under the law. The grand jury, though, has deemed probable cause exists otherwise, and that's where we move from.
Okay.
The law provides that the bonds that are set are not necessarily a hearing based upon a hearing of witnesses, but based upon information that the court has. I have probable cause affidavits in each of these cases, and other information that the court has referred to. The legislature that enacted this law set forth this confinement, this punishment for each of these offenses. It is only superseded by capital murder convictions. That's the only more serious punishment range in the state of Texas for such a crime. So it has its level of seriousness, which is most high, that the legislative branch set the laws for. So, and the court bases bond hearings on a couple of things, not the least of which are the information that the circumstances of the crime alleged and criminal histories. Those are the two major components. Here, I don't see a criminal history as a factor. Nonetheless, the seriousness of these allegations, as found, probably occurred based upon probable cause of the grand jury decision, or, as we said, such a serious crime. Only more serious is capital murder, which is death penalty. And what we're also speaking about is that the victims are not adults; these are children. What is the price of the loss of the innocence of a child? What is the price? What is the value? Anybody want to say there's something more important on this planet than that? No. That's what we're talking about, these circumstances. So, anything else you want to add? You wanted to say something?
I mean, I'll comply with whatever conditions the court sets for me. I mean, GPS tracker, whatever y'all want me to do.
How does that prevent you from harming another child if this occurred?
I did.
How would this prevent you from harming a child if you wanted to? How does the global positioning track device prevent that? It just shows where you.
I don't drive.
It doesn't prevent you from committing an act.
Well, chemically castrate me. It doesn't matter. I didn't do it.
Okay. Well, that's why we're going to have a jury trial on this, is what we want, right? On a jury trial. Let's get this moving. We'll get this moved quick enough.
Yes, sir.
Your request for a bond relief is well presented. It's denied. The court feels the circumstances of the offense as the probable cause affidavit show. Put this court in such a position. How can I guarantee a child safety under these circumstances. And yeah, you're presumed innocent. I wrote the leading article on that. I'm in the state of Texas, so I believe in that. But the probable cause, but the law states circumstances of the crime through the information that the court has, or is part of the equation in determining bond. And I'm going to say again, only capital murder this court finds is more serious than the allegations of two separate indictments alleging two different victims in these cases. So that compounds the problem. There's not one. I'm looking at the public safety report here that the court is required to review. And this shows that in 1999, you were charged with illegal possession of marijuana and burglary of a habitation. What happened in those?
It was dismissed, so.
I don't know what happened. I just now heard about that.
You don't.
Whenever after the my arrest.
This is under your name, under your data. It's it's
No, the specifics about.
supervisory caution. It says supervisory caution, whatever that is.
I would have to do like.
There was no conviction, whatever it was disposed of.
And that's all the court is really on criminal history. If you don't have a conviction, there's not. Now, but then people could be placed on deferred or unadjudicated probation and admitted.
It doesn't.
But that's not what I'm saying.
Case
Okay.
If, sir, somehow you were able to provide bonds in these cases, the magistrate who set these bonds originally at $500,000, I can't read the signature.
We'll show up.
But he or she provided that there will be no contact at any time of the victims. You must have a GPS device and remain in Jefferson, Orange, and or Newton counties if you were able to post a bond. So those would be required if you were able to post a bond in these cases.
Why bond? No, just.
Anything else?
No, sir.
All right. Again, the probable cause affidavits are part of this hearing in each of these cases, plus the public safety reports. All right. And this will be set with how you want to represent. And when can the state be ready on this? We're going to fast track it.
Yes, sir. Since we got holidays coming up.
I know it has to
We
be.
could do it right after the holidays because these girls.
Can we set it for late January?
Yes, sir.
All right, it'll be set for January. Thank you.
Thank you.
Your Honor, may I approach?
Oh my goodness. What a case that is. Actually, two cases. Continued abuse of that kind to children, 10 or 11, 12, 13 years old. My word. You know, I was going to go back to Judge Boyd following that, but maybe we need a little bit of a palate cleanser. Maybe we need something that's a little bit lighter. So let's see what's going on elsewhere. It looks like Judge McNally is doing civil stuff here. So, that'll lighten the mood just a little bit. Let's check in with Judge McNally and just sort of wash that out. Yes. Oh, are we having another audio issue here? Let me see. Oh, hold on.
Yes, Your Honor. William Hill on behalf of
there
the
we go.
plaintiff.
Okay. Do I have Andre Johnson here? This was scheduled for 10:30.
He is, Your Honor.
All right, Mr. Johnson, your name?
Andre Johnson.
Counsel, this is your motion for summary disposition.
Yes, Your Honor. This is a motion for summary disposition based on 2.116C10. There's no genuine issue of material fact. This was a credit card, a defaulted credit card that was issued by Citibank back in November 26th of 2021. Payments were made, charges were made, payments were made, but the last payment received was in May of 2023, but eventually it went into default and was charged off and purchased by Middleton on January 29th of 2024. All of the supporting documents showing chain of title and the transfer of the documents were attached to the motion, along with the various charges. Middleton is seeking judgment today in the amount of $2,459.29 plus $123.60 in costs. Total judgment $2,582.89. A proposed judgment should have been submitted with the motion.
Sir, you did not file a response. I can safely assume that you agree that you owe that amount?
No, I did not owe that amount, and I didn't know.
Okay, you got to keep your voice up. You're supposed to file a response if you disagree, but I'll listen to what you have to say.
Yeah, I didn't. I disagree because I didn't know. Honestly, I don't know the court system, and this is the first time me been.
Nice and loud for me, sir. Nice and loud. You're not, get close to the device.
Can you hear me now?
Yeah, that's a lot better.
Okay. So I didn't know I was supposed to write into a response because it was all supposed to be subpoena. I don't recall owing $2,500 or anything of that nature. I never got that card for that much amount. And the payments that I did make on it, I was making
What do you think
payments,
you owe?
and then I closed the card.
What do you think
So
you
as
owe?
soon as I closed the card, there was no other processes that they gave me to continue to pay off the process. But I honestly cannot afford. I'm not denying that I had a city card, but I'm denying the fact that 2,000 and however
How much
much
do you
amount,
think
the
that
dollar
you
amount
owe?
that he just said is incorrect completely,
much-
especially if I was making
Stop.
payments on it.
Stop. How much do you think that you owe?
Honestly, I can't tell you how much I would still owe because it was in 2001. That was right after COVID. I couldn't tell you, but I know I took out a city credit card. But I could tell you what I could probably come to an agreement with city, but other than that, I can't afford $2,000+
Well, the question isn't whether you can afford it. The question is whether or not you owe it. They
Well, I-
filed documentation. You were
I did not
obligated to file. You were obligated to file documentation, affidavits, pleading something that tells me you didn't owe that, and you didn't file anything, and I have no choice but to grant their motion for summary disposition. I'll be happy to set up an installment payment plan for you, sir. But I'm gonna have to enter that judgment for $25.8289. If you tell me how much you can afford to pay weekly or bi-weekly, and everybody agrees on it, or if they don't, I'll rule on it, then that's the amount that you can pay, and they can't garnish wages so long as you pay that amount on whatever interim basis that is. Do you understand that?
I understand that, but when was I supposed to get the notice of them filing that? Because the first notice I got was the filing of disposition. They never asked me for a summary.
Okay. Tell me where you work and how much you owe. Make rather. How much you make?
I work for the union, 687. And I would
How
say
much
I'll
you-
probably owe $1,000, if that.
How much do you make, sir?
I only make $1,000 a week.
How much per hour?
I make $38 an hour.
Well, you're making more than $1,000 a week. If you're working 40 hours, you're working 40 hours, right?
It's not always guaranteed, sir, in the union.
How much can you afford to pay weekly?
I could probably afford $50 weekly.
Mr. Hill, what do you think?
That would be roughly $200 a month. That would be acceptable to Midland.
You pay $50 per week. I'm going to start it beginning to November 17th, okay?
Okay,
They
but I'm
keep-
still
they-
trying to understand when was I gonna get the summons to
I don't know
even
what you're
fight the
talking about. You
deposition?
got the summons a while ago, sir, and he
What
filed
date?
a motion. Listen to me, please.
What
You keep
date did I get it?
interrupting.
Because I did not ever get it in my mail. I got the summary of disposition. And that's the only piece of paper that I got from Midland Credit.
You filed an answer in September, right?
Yeah, to say do I agree? And I said no, I do not.
Well, that's fine, but they filed a motion. You just said you got the motion. You needed to respond to that. You didn't respond. I mean,
did
look,
respond. That's the only reason why we're in the courthouse today. I had to file a personal response in handwriting to bring it up to Trenton's 33rd District Court. And this was the next move after that. I didn't get a summary. I didn't get to see their disposition of where these payments are coming from. I didn't see their records of everything that they say they have. I have no idea.
Jennifer, can you
That's
enlighten
unfair
me
in
on
the
this?
trial. I have no knowledge of what they know already.
Sure.
Judge, their motion for summary was filed with this court on October 2nd.
Yeah.
I'm pulling up to see what their proof of service said. We still have Mr. Johnson's address as 39 in Trenton on Detroit.
Yes.
Well, you got the motion. You just said you got the motion a couple minutes ago.
No, I got the first letter of being sued.
They mailed their proof of service indicates that they mailed it on September 26th, indicating today's court date at 10:30.
And who set that, who set the time? Did we send that out?
They sent it out on their notice of hearing, and we sent a secondary notice.
Okay, so they sent it to you. We sent it to you. I mean, you have to take action on these things, sir. You can't just come in here and say, I don't know what I owe, but I don't know that. The perfect thing, the beautiful thing about math is there's only one right answer. It's not subject to debate. You've
And that's
given
the
me,
thing, but the court system is there's a proper channel to go through. They only subpoenaed me to be sued. It was a yes or no question. Do you owe this amount? Yes or no? I told them, no, I do not owe that amount. I got no, like I said, I have no records of what they see, of what his charges are, of what I've paid. I have no knowledge of what he's looking at. It's only fair for me to know what he's looking at if he's looking for me to have the same
they
information.
sent you the motion
makes
for
no-
some, they
it
sent
doesn't-
you the, listen, they sent you the motion for summary disposition.
That means that you're instantly going for the full amount. You gave me no chance to fight.
Mr. Johnson, I don't know what you mean when you say that.
There was no pretrial conference. I've never met with this man to come to a settlement agreement. I've never came up with anything with Midland Credit. Nothing.
They have the right to file a motion.
Instantly
filed a
going
mo-
for the disposition.
You keep interrupting me.
I'm not understanding you.
Well, let me be clear. They filed a motion. They sent it to you. You needed to respond. You filed no written response. You didn't file any affidavits. You didn't tell me that you don't owe this much by affidavit, and you didn't tell me how much you owed. I asked you verbally. You said you did not know. I don't know how somebody can not know and then have me take them seriously. It's math. It's something that's easily discernible. You didn't take the time to figure it out.
It's an
easy-
account from
You keep interrupting
2001.
me. Listen, this conversation right now is over. And if you want to file a motion for reconsideration and provide me with documentation that changes my mind, I'll be happy to consider it. But you can't just come in here and argue with me and provide no proof. Mr. Hill, send me your judgment. Thank you.
I want the proof from them.
I've heard enough. Thank you.
That's
Thank you very
unfair. I
much.
want
Good luck.
to
Mute him, will you please? I'm not gonna listen to this nonsense.
Your Honor, for clarification, I believe a proposed judgment was attached to the motion. You should have one.
I don't see it. I do not see it. I mean,
Then we'll resend it then, Your Honor, if
Thank you.
if you don't have it. Thank you.
thanks. Okay, what else do we have here?
All right, Judge
Do we have
McNally.
LVNV versus Ossenmacher ready to go?
Judge McNally is upset. Let me do a little side tangent here, a little story time with Mike. All right, if we can do that, just real quick. Let me bring this up. Let's just do a little story time with Mike. So the plaintiff in that case is Midland. All right, Midland Credit. A couple of months ago, I had my own dealing with Midland Credit because they claimed that I owed them $3,300 on an account. And of course, I had never opened a Synchrony account before, but they claimed that it was from Synchrony. I called Synchrony. They said, we have no idea who you are. We've never heard of you. You don't owe us anything. And so, but supposedly Midland purchased this debt that I owed. So of course, the one and only Michelle and myself, we had to scramble around and write a very strongly worded letter to the fine folks at Midland challenging this. This is what you do. You challenge them. And they said, oh, sorry, our bad. You don't actually owe us the money. But they were ready to just take $3,300 from me. Obviously, I don't have $3,300. I'm not the big YouTube sensation that Dan Soul is here that normally sits in this chair. So I don't have the $3,300, but of course I don't know that. I pay my debts eventually, sort of, kind of. Have a lot of those, but we're working that out. Which leads me into this. If you want to help us out, support the channel, support me, super chat, super stickers, all that stuff. It's all good. Thank you again, Barbara, for the gifted membership, and Joan for the $10 super chat earlier today. Really do appreciate that. Now, that case probably got me just as mad as the case from Judge Simmons' court, because I know that those Midland folks are a bunch of grifters. So you want to get me upset, get me started on some grifters. All right. Anyway, sorry for the side tangent there in the middle of a TCF live, but sometimes that's where you got to go. All right. Let's see. Let's get you back to where should we go? Let's go to Judge Boyd. What do you guys say? We gotta, I don't know. We'll close up strong here today. We'll go out to Judge Boyd. We'll see what she's got going on. Should be exciting. Let's see if I've got Judge Boyd here. There we go.
Court is calling 2024 CR 2985. State versus Daniel Ramos Balderas. Could I have parties announced for the record for the state?
Lauren Espinoza.
Defense?
No, I go for the defendant.
And are you Daniel Ramos Balderas?
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Daniel Ramos Balderas who was placed on deferred adjudication in 2024 CR 2985 for the offense of unauthorized use of a vehicle on June 24, 2024 for a period of 2 years? Is that you?
Yes, Your Honor.
All right, state. No problem. Oh, do you want to use mine?
Yes, please. Thank you.
You're welcome.
Violated condition number 1 on or about the 23rd day of August 2025 in Kendall County, Texas, the defendant Daniel Ramos Balderas committed the offense of evading arrest in violation of condition number 1.
How do you plead to that? True or not true?
Your Honor, my client's requesting a reset. Can we move forward?
I'm sorry, what?
We weren't expected to move forward. We were requesting a reset today.
No, I mean, we are moving forward. So does he plead true or not true?
Not true.
All right, how do you plead true or not true?
Not true.
All right, read the next. Are you going on?
There is another condition number 1.
Yes.
Violated condition number 1, on or about the 23rd day of August 2025 in Kendall County, Texas, the defendant Daniel Ramos Valderas committed the offense of evading arrest and commission.
How do you plead to that? True or not true?
No, not true.
And then we'll waive the rest.
All right, do you object to the waiver of the other violations? All right, so I'm so sorry. You're gonna have to speak up so I can hear.
No, no.
All right. And state these are the only 2 violations that you're proceeding on?
Yes, Judge, I spoken with the prosecutors out of county and they were those 2, so if we were to proceed with the full on hearing to do those.
Okay, all right. And when will you all be ready for the contested?
Your Honor, I would defer to Mr. Daggett. Our witnesses will be coming from about 2 hours a day, so whenever this is fit for the schedule.
All right, Ms. Ferguson. This will be reset in 10 days for a contested hearing.
Yes, sir.
What date?
You do.
All right, November 13th, there will be a contested hearing. You will be brought over. Do you understand? Any other questions, counsel?
No.
All right, thank you. Have a good one.
Have a seat, sir.
It's TCF Live. It's Monday. It's Judge Boyd hanging out there for a bit. And getting used to the new, the time change happened. So here in Arizona, we don't change our clock. So I had to start the show an hour later.
Is the attorney still here on Daniel?
And so we're hanging out an hour late. Normally the show would be over by now, but we still got a few minutes left to go in the day. Maybe we'll scoot a couple of minutes into overtime. We'll have to see what happens here, but we'll wait for Judge Boyd to have the next contestant to come on down.
For a contested today.
All right. We're in the Wayback Machine a little bit here, so let's see if we can't get this. Here we go. There you are.
Up there. There. Yes. That's it. 12-3, yes.
Okay. So State, were you able to tender an offer?
Yes, sir.
All right, so what I'll do is I'm going to set this for a plea deadline date and towards the end of December. When I say the end of December, the last week in December that everyone is here.
Okay.
All right, Ms. Ferguson,
Yes, sir.
the last week in December that we're here, please.
December 16th.
December 16th,
Can we do December the 3rd?
the
The
3rd.
3rd? Yes, ma'am.
All right, Norma, can you put that on December the 3rd?
Yes, sir.
Thank you, Your Honor.
All right. So that will be your plea deadline date. And then if a plea is not reached, then we can set it for hearings and do a trial schedule.
Perfect.
Thank you, Judge.
Yes,
Great,
ma'am.
thank you. Thank you
Thank
for
you.
addressing it appropriately for court. Once you sign the reset form, you're
Thank you.
excused.
Thank you.
And they are having your client brought over.
I can hardly wait. Okay, thank you. I'll take that.
Anyone else ready?
Yes. Or fourth one down.
Luis Briceño?
Okay.
Okay, let me see here. All right, today is plea deadline date.
And Judge, we are not going to take the state's plea offer, so that's why I
Okay,
indicated we'll probably reset that for a while.
all right, State,
Judge, Judge, he just stepped outside just for a moment.
You can hang out.
All right, all right. All right, who's next?
Next, we have, page 2, first one down, Dorian Maria.
Dorian Camarillo.
Yeah, great. All right, ladies.
All right, on this case, the state tendered an offer.
They tendered an offer, Judge.
All right, then. So you all will be back on December 3rd for your plea deadline date.
We did.
Mhm.
Judge. This is a capital case, Judge.
No, I understand that. So if you all don't reach an agreement, then we can do our trial schedule. You can file whatever motions you want to file. But
Excuse me,
yes,
Judge, I just conferred with the state. We've received 95% of the discovery. There's one item that I'm not able to open. It's referencing anything related to Apple products.
Mhm.
So we're trying to hammer that out to see how we can get it.
So I gave it to her. She's just having trouble accessing it. So I told her during the week of Thanksgiving, we don't have a lot going on. If she wanted to come over, we could try to
Figure
out why hers isn't, it's not opening for her. But that's all I know on that stuff.
all right. So y'all need to come back on November 17th and figure out why it isn't open and it needs to be open. And then you're going to be set for a plea deadline date in December. All right. So Norma, recall this for November 17th. Thank you.
All right. I'm glad to be brought to come.
I know. Well, you know, because this is
Weekend, but we got robbed on Saturday.
But there's a lot of robberies going on. But I don't know why your information is not opening, because the co-defendants, they were able to open theirs.
I don't think it's conspiracy, Judge. I just hope we'll get to the bottom.
Is it a COE conspiracy?
We'll try to resolve the situation.
Because I wanted to give them a plea deadline date for the end of December. They're like, could we do December 3rd? So you all should have came up before them.
Okay, all right.
All right, see you back on the 17th.
17th.
Yes, thank you.
November.
Yes. All right, Brasenio. Family violence, this is your case. All right, how long do y'all expect this trial to last? All right, Ms. Ferguson, I need a 3-day for a jury trial for family violence. January 27th.
January 27th.
All right, once you sign the reset form, you're excused. Thank you. And you all need to make sure that I have the acknowledgement of discovery.
I'll do that right now.
Thank you. All right, who is next?
On page 1, this one down, Juan Martinez.
Juan Martinez.
Still downstairs.
All right, they're bringing your client up, Mr. Featherston.
Thank you, Your Honor. We'll wait.
All right, thank you. Anyone else?
Page 3, fourth one down, Matthew Mauer.
Matthew Mauer? Yes. Hello, counsel.
Morning, Judge. How are you?
All right, so today is plea deadline date?
Yes, Judge.
The plea involves us actually pleading on another case, and this case being dropped, which I have to go work out the other case. I don't know what, I'm asking for a reset for that with the anticipation. So whatever type of reset we need, if we need to set up a trial, we can do that as
Well,
well.
what date is that taking place in the other court?
Well, I'm gonna go talk to them today and then set the plea in that court. So I mean, within the next few weeks, I anticipate. But it's not all done. That's
All right, Norma,
Yes, ma'am.
set this for, will you be able to have it done the week of November 17th?
I think that's fair, Judge. Yes.
All right, Ms. Ferguson, can you set this for maybe November 17th, 18th, or 20th?
Thank you.
All right, so we'll be back on November 20th. If everything is taken care of, then of course you won't need to come up here.
Perfect, Judge.
All right, thank you.
Have a great day.
You too. Once you sign the reset form, you're excused.
Thank you.
Thank
Judge.
you. Thank you.
Thank you.
All right, who's next? Anyone else ready?
No, just remember one defendant for Paul Martinez.
All righty.
All right. Well, I suppose that seems like a fairly logical place to sort of wrap things up. Kind of a quiet end, sort of a subtle end to today's affairs here on TCF Live. Oh, man, what a day. Thank you so much for joining me as always. I really do appreciate that. Michael Groff filling in for Dan Soul all week. And you want to support the channel, of course. The Courtroom Files here on YouTube, courtroomfiles.com for all your Courtroom Files merch. Thanks to everyone for the super chats, super stickers, the channel memberships, all that stuff helps out the channel greatly. Really do appreciate it. You guys hanging out in the chat, all that algorithm stuff, the fancy YouTube stuff. We really do appreciate that. And of course, you want to, for whatever reason, if you feel so compelled to do so, and you just can't get enough of seeing me here, well, then you could always check out my other channel, it's Michael Groff on YouTube, the Phoenix, Arizona Weather Discussion. We do weather for here in Phoenix and across Arizona. And I know it's kind of niche content, but it's fun content. We do stuff over there, and I promise you, I bumble and stumble around over there just as much as here. So you'll always get my best. That's for sure. All right. Well, this was fun. And I really have enjoyed filling in for Dan and holding the fort down for him. And of course, we wish him a speedy return and a safe return, him and his family. After all, Ellie is back at home and probably misses him quite a bit. So you'll get to look forward. We haven't seen Freya around here. Freya is our cat. Now, if you've been playing our TCF bingo, you can just substitute me for Dan on any of those bingo squares and Freya for Ellie. Freya is my cat. Ellie is Dan's cat. But Freya has been kind of because she's been roaming around the house and stirring up trouble, I'm sure sitting on Michelle's laptop and other computers downstairs and creating general havoc. Sometimes she's up here doing that, and or she's on my shoulder, or she's over here on the keyboard, the piano. But whatever. Anyway, thank you so much for joining me. Back here tomorrow morning, 10 a.m. East, 7 a.m. Pacific, 45 minutes early for channel members. You get to see Dan there. He's doing the pre-show, and then you'll get more of me, because what could be better than that? We'll see you back here tomorrow morning. Thanks again, everybody, for joining me. Have a great day, everybody. Goodbye now.